Not because my client wouldn't diffuse, because Smoke, the person he doesn't know, would not diffuse, would not stop. And he felt that he needed to clear his name. Then you had Detective Sedling, and he is the gentleman that did the sketch. Remember, the sketch is not to scale. But you see the way the firearm fell. State's Exhibit 32 is prior to them putting the yellow placards up. State's Exhibit 54 is after the placards are posted. Those were all crime scene pictures. You also heard from Ms. Forte. She was not there, but she had seen her son on the news. She welcomed APD in because she wanted to know both sides of the story. She said she had a conversation with my client that he had indicated he had to do it because the gentleman had a gun and that the victims were posting them on Instagram and they were scared. She specifically said that nobody, including my client, came to her house afterwards. Then you heard from GBI, who indicated to you that the GSR kit would not be tested, was not tested. You heard from the arresting officer, who indicated to you that my client was compliant upon arrest. And then you heard from the lead detective in this case. She told you that Smoke was armed. She showed you a video compilation, and in that video compilation that she did not prepare, she indicated to you that Smoke goes to the stairway area for 5-ish minutes, walks around the building for roughly 20 minutes, returns to the stairway area for 5-ish minutes for a heated debate. She testified to you that no evidence proves that Smoke did not pull his firearm first, no evidence that anything was stolen from Smoke, and testified to you as an officer and under oath that it just looked like his hand was on his hip. Ladies and gentlemen, that is wrong. You want to determine credibility? You see how it looks when he grabs his firearm. This is how his body is when he touches his firearm. It's the same movement, the same hand to the waist. Oops. Then you heard from the medical examiner. He wasn't provided the video surveillance either to compare, but he explained to you that homicide doesn't mean murder. And you know, one of you asked a really good question about a toxicology being performed, and that nothing was even tried in this case. Ladies and gentlemen, as soon as they got the ring footage, not knowing, and there was an anonymous caller they indicated, a neighbor that they spoke with, but nobody ever tried to really figure out why. Why did Smoke start this? Why? I mean, you hear and you hear from Ms. Parks that, well, she said there wasn't an issue. It's weird because she said there wasn't an issue, but she also talks about the picture on the phone and saying that happened around March or May, months before this incident occurs. So it's for you to decide why. You heard from GBI Holman, who indicated that the gun was not full at the time that she reviewed the firearm. And then you received the evidence. And out of all of this evidence, you received over 150 pieces of evidence, and not one piece disproves that Smoke clutched, pulled, moved, prepared, threatened my client with his firearm. Not one piece of evidence shows otherwise. The law is that no person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The state must disprove beyond a reasonable doubt the affirmative defense that we have raised. So what is justification? A defendant is justified in using force that is intended to or likely to cause a death or serious bodily harm when one, he or she reasonably believes that the use of such force is necessary to prevent death or serious bodily injury. So there argument is that it was excessive. It was 6 shots. But the reality is excessive force means when 2 guys are in a fist fight and one pulls a firearm. That's excessive force. When one individual is consistently the aggressor for over 10 minutes, split in 2 moments of 5 minutes with 20 minutes in between, and that individual shows them there's a firearm. Now, this isn't just a fist fight. And there's no duty to retreat if you are not the aggressor. The judge will also review this law, threats justifying a homicide. And that even if there's no physical contact between anyone, that if the menacing action of that young man is sufficient to create a reasonable belief that my client was in imminent danger, forcible felony was about to be committed, then his use of deadly force may be justified. And that's a decision for you to make. The law on grave suspicion. Judge will read this, you'll see it, it's page 2. That's how high up it is. The evidence that merely places upon the defendant grave suspicion of the crimes charged or merely raises speculation about the defendant's guilt is not sufficient. Ladies and gentlemen, this case, reasonable doubt is about giving reasons. So here are some reasons. There's no evidence that disproves that Smoke was the aggressor. There's no evidence that disproves that Smoke threatened Mr. Tuitt and produced his firearm. Instead, Smoke confronts Mr. Tuitt 20 minutes after his initial 5-minute argument. Mr. Tuitt never approaches Smoke or his home, never leaves that stairway area. If Mr. Tuitt wanted to shoot him, he had over 10 minutes to do that. And the big picture here. So, ladies and gentlemen, Mr. Abadi is really good. He is a great attorney. And he's going to get up here and he's going to tell you I'm really good too. Right? Right. And so what he's about to do is he's about to show you a presentation. And in his presentation, he will believe this is the eye-opening moment, or as the state told you, the aha moment. But the problem is you can't break this down slide by slide, frame by frame, because it's a bigger picture. It's a 30-minute picture. Ladies and gentlemen, he's going to focus on 6 shots. 6 shots that happened within seconds. But you have to remember, this is August, middle of the day in Bankhead. It's hot outside. The police are outside. Their intention was to simply smoke a cigarette and go to the mall. That's what their plan was that day. Instead, Smoke had found out that his girlfriend didn't come home the night before. And you see how he came out of the apartment. You see that when he came back, he had produced his firearm. You see that no matter who was around, the police, the witnesses, Forte trying to defuse the situation, that he would not stop. The big picture in this case is about what you know, who you know, and how you know them. The big picture in this case is that he would not stop. Ladies and gentlemen, I humbly ask you to apply the facts to the law, to seek the truth, and to render a verdict that my client is not guilty. Thank you.
Thank you, Ms. Fagan. Ladies and gentlemen, we're going to take a quick break before Mr. Abadi gets up to give the state's rebuttal. You should go to the jury room. Don't talk about the case yet. You still don't have the law. No outside research. We'll get you back in here 5 minutes-ish after their equipment is set up and Ms. Rivers has been able to stretch her fingers with some nonstop talking. Thank you. You all can be seated. Two quick things before we break. One, I will give to Ms. Rivers during the break the 16 note cards that were submitted by jurors as juror questions. They'll be Court's Exhibit 1 and made part of the record. And two, I'd ask the lawyers to think amongst themselves and then confer if they want to have juror 5 serve as the alternate or as a regular juror based on concerns she's raised. She's made it through the week. That's all good. But there were additional concerns about having to make a decision and the stress that might cause. And so I flagged that because we have the flexibility of saying she's the alternate or not. But that needs to be something where I get input from both sides. Okay. Enjoy a quick break. I'll be back out here in a few minutes. Mr. Abadi, if you could get your stuff set up. Thank you.
Okay.
Let's go back on the record in State versus Tuitt. Mr. Tuitt is back in court with his lawyer, Ms. Fagan. She has completed her closing presentation. Ms. Fagan, anything we need to discuss before the jurors come in?
No, Your Honor.
All right, Mr. Abadi, you ready for the jurors? Yeah. Let's bring them in, please.
All right, to the jury. Who's the president of the county court?
Thank you, Deputy Gordon. Everyone else should be seated. Ladies and gentlemen, we have one piece remaining to the closing arguments. You heard Ms. Jones-Connor with the state's opening to its closing. You heard from Ms. Fagan for the entirety of the defense closing. And now Mr. Abadi has an opportunity to share the state's final words. And then we'll move right into the jury charge that I need to give you. Then you'll begin your deliberations. Mr. Abadi, when you're ready.
Thank you, Your Honor. I told you I'd be tired during this talk at the beginning of this trial, so I'm going to keep this brief, I'm going to keep it concise, I'm going to keep this to the point. And one thing that Ms. Fagan said at the end during her closing, and I completely agree with her.
How great you are.
Glad to. How great you are, how great you are, how great we all are. The one thing I agree with is that in this case, y'all's duty is about the evidence. And what the evidence showed over the last couple of days to prove this defendant guilty beyond a reasonable doubt for murder. This case is about the defendant's anger. It's about the fact that he was tried, his pride got busted, and the choices he made because of his anger and his pride of being questioned. That's what this is about. And because of those two things, the choices he made was to pull the trigger at close range, one of them with the muzzle of the gun embedded in Quintavious' right chest, embedded in his chest, and pulled the trigger. Ladies and gentlemen, that's not self-defense. This defendant is attempting to use the concept of self-defense as a license to kill because somebody tried you. Because that's what he told you. That's the evidence. There's not a single piece of evidence that this defendant, that Mr. Tuitt, said that he was scared, that he was in fear, that at any point he felt that he was about to receive serious bodily injury. You never heard that from this defendant. He talked to Ms. Forte, he talked to Mr. Forte, he talked to Ms. Parks. Not once did he say any of that. He said he was tried. When Ms. Forte gave him the opportunity to say it was self-defense, he said, no, I shot him 6 times. Not yes, I was scared for my life. Not yes, I was fearful that I was about to be killed or that I was about to receive serious bodily injury. Absolutely none of those things were said. Instead, he then tells Ms. Parks that Street did it. Again, not that he was in fear, not that he was scared of anything, but that somebody else did it. Then he had the opportunity after his arrest. He made the choice to speak to Detective Johnson. What didn't you hear again? I was in fear. I was scared. I was about to be killed. I was about to be injured so severely that I had to protect myself by shooting somebody 6 times, with the first one being the muzzle of the gun imprinted into the chest of Mr. Wright. That's not self-defense. That's murder. That's the facts. That's the law. That's what you heard over the last 3 or 4 days. Nothing more and nothing less. Now let's talk a little bit about the facts that we heard about, that we can all agree on. We heard that both the victim and the defendant lived at the Parkside Apartments. The victim lived in 2308 with his girlfriend and mother of his children, Miss Raquel James. Miss Parks and the defendant lived in apartment 2103 with her older daughter. And the defendant is a convicted felon. You heard that. You saw that in State's Exhibits 140 and 141. That because this defendant is a convicted felon, that it's illegal for him to be in the possession of any firearm. That Mr. Wright and Miss Parks known each other for several years. They've known each other since grade school and got reacquainted when they both realized they lived in the same complex. That sometime during the summer of 2022, when the electricity bill wasn't paid, Miss Parks confronted the defendant about a screenshot she saw or that was shown her by Mr. Wright and friend that this defendant was cheating on her, that he was paying for sex. So she said something to the effect, you can't pay the electricity bill, but you can pay for sex. Something of that nature is what she described. She testified that after she said that, she knew it was clear that the defendant knew that Mr. Wright told Miss Parks that. The defendant, Mr. Forte, on August 7th of 2022, they were in and around the apartment at 2303 in the Parkside Apartments. This defendant, again, he's a convicted felon in possession of a firearm. You saw it. Ms. Jones-Connor showed you several pictures. And on August 7th of 2022, this defendant was in the possession illegally, because he's a convicted felon, of a black handgun. And the evidence, as it unfolded through the course of this testimony, and after you heard from Ms. Abby Holman from the GBI, that it's the firearm, that black handgun, was consistent with being a Glock 9mm. How do we know that? Because all of the shell casings that were tested came back to one gun. That one gun fired those shell casings. Not the pink gun, a different gun, the defendant's gun. And what Ms. Holman told you is that as it relates to those 6 shell casings, that they were fired from a 9mm Glock handgun. There wasn't a list, there wasn't a long or different options, but it was a 9mm Glock. Mr. Wright and his family were home that day on August 7th of 2022, and they, again, were living right down the hall. That Miss James left the kid with the kids to go get her nails done around 1:24 p.m. That shortly thereafter, around 1:28 p.m., Mr. Wright, you saw in the video, he walks out of his apartment, 2308, towards the stairs. And what you saw, and what defense counsel neglects to acknowledge that you never addressed, is that Mr. Wright turns out of his apartment. He's walking down the 3rd floor breezeway towards the staircase, minding his business. He doesn't go knock on Mr. Tuitt's door. He's not screaming Mr. Tuitt's name. He doesn't kick in the door. He does nothing but continue to walk, smoking his cigarette, minding his own business. And the minute he comes in the area, as he passes the defendant's apartment, who comes out? The defendant. The defendant initiates, intercepts, starts the interaction with Mr. Wright. Not Mr. Wright. And then as Mr. Wright continues to walk towards the stairs, what does the defendant do? Doesn't go back into his apartment. You never actually see him smoke a cigarette. He follows Mr. Wright. Mr. Wright begins to talk to the 2 gentlemen that are coming up the stairs. Mr. Tuitt stays there, just hanging out in the area, crowding Mr. Wright, who was just walking down the hallway, minding his own business. Again, you know that Mr. Wright wasn't going to Mr. Tuitt's apartment because he doesn't knock on the door. He doesn't even look in the direction until this defendant intercepts him as he's walking out. Who don't you see? You don't see Mr. Forte. You eventually see Mr. Forte come up the stairs after the 4 gentlemen, Mr. Wright, Mr. Tuitt, the 2 individuals, go down the back staircase. You don't see them, they're out of the camera view. And then you see Mr. Forte come up. You see Mr. Forte go into apartment 2303, get his black bag. He told you it was full of marijuana. You see him go back down the back staircase. And a few minutes later, at 1:33, you see the victim by himself walk back up. As he's walking back up towards his apartment at 2308, you see the gun. You see his pink gun holstered or placed in his waistband. And Mr. Forte told you, and Mr. Connor talked to you a little bit about the credibility and the believability of the witnesses. What Mr. Forte said on this stand in front of each and every one of you was corroborated. And how was it corroborated? Because as Ms. Fagan pointed out, when the victim, Mr. Wright, initially is walking down the hallway, minding his own business, around 1:28 that afternoon, when he intercepts the defendant, you don't see that handgun. It's not in his waistband. It's not visible. What Mr. Forte tells you is that when he initially sees the defendant and the victim start to communicate, argue, whatever you want to call it, that's after they've gone down the stairs. Because Mr. Forte wasn't part of that initial interaction. He's on the second floor. He's somewhere below the third floor on the stairs. He tells you during that initial interaction, the defendant or the victim moves his gun from his pocket and puts it in his waistband. That's between 1:28 and 1:33. The shooting happens at 1:54, 1:55, a solid 30 minutes. But Ms. Fagan wants you to believe that Mr. Wright's the aggressor. Mr. Wright won't stop. Excuse me, she calls him Smoke. And I want you to use your common sense. I want you to think about why she keeps calling him Smoke. She keeps intending to imply something that the evidence and the facts did not show. Did not show. What did the evidence and the facts show about Mr. Wright's nickname being Smoke? Is that was his stage name. That when he rapped, he went by Smoke. That's it. No one else called him Smoke. You heard from the other witnesses. You heard from Ms. Parks. You heard from Ms. James. They didn't call him Smoke. They called him Quintavious or they called him Tay. But use your common sense and reason as to why Ms. Fagan keeps repeating Smoke, Smoke, Smoke. She wants you to believe something that's not true. She wants you to believe something that the facts and the evidence did not show. There was no testimony about anything other than the fact that Smoke was his stage name. About a minute later, from 1:33 to 1:34, you see Mr. Wright exit apartment 2308 and go towards the elevator, goes down the elevator. You still see the gun in the same area of his waistband as he exits on the floor labeled T out that side gate. At 1:45, Mr. Wright enters the front gates of the building, 2000. You see him again as he's walking through that front gate. Gun still exactly where you saw it at 1:33, hasn't moved. And this is minutes before, 10 minutes before the actual shooting occurs. You see him walking through the first floor. You see him go up that first floor flight of stairs on the back side of the building and go up. And then you see him on the third floor having a conversation, an interaction, what turned out to be an argument with the defendant. But defense counsel wants you to believe that Mr. Wright went up the stairs knowing that the defendant was going to be waiting there at the stairs to then initiate or start another confrontation or conflict. There's no evidence of that. There's absolutely no evidence of that. He's using the public staircase to walk up and go to his apartment, which you saw him doing initially when he was attempting to leave when he left his apartment at 1:28. There's absolutely no evidence, there's no testimony that he took this route in order to purposefully and coincidentally interact with this defendant. That's just not the evidence. That's what they want you to believe, but that's not the facts. Now, what we know, and as Ms. Jones-Connor talked to you about earlier, motive the state doesn't have to show you to prove, but we have the testimony of Ms. Parks that fairly recently there had been a comment about paying for sex but can't pay for bills. And then you have Mr. Forte talking about that the argument was started about Miss Roxy or Ms. Parks, and then kind of morphed or continued into the fact that Mr. Wright disrespected this defendant. He tried him, and so he shot him out of anger. He didn't shoot him one time, he shot him 6 times. That's how you know it was out of anger. That's how you know it was due to the fact that he had been tried. The fact that he held the gun to the chest, the muzzle embedded into the chest of Mr. Wright, that tells you that there's no way that Mr. Wright clutched, brandished, pointed, touched a firearm. Because use your common sense. If Mr. Wright pulled the gun first, how does somebody get the muzzle of a gun on your chest when you're not shooting one time? And you know, as defense counsel tried to imply, that some of the shell casings could have rolled or whatever it may be, and they weren't collected from the gun of Mr. Wright that was found near his body. How do you know that's not true? You know that's not true because Mr. Tuitt isn't shot. Because again, they're feet apart when Mr. Tuitt shoots Mr. Wright 6 times. How else do you know that's not true? After Mr. Wright is shot, his position, his body doesn't move before he goes down. So if he shot his gun that's not seen on the video for some odd reason, there'd be a hole in the wall near the defendant's apartment. There's no evidence of that. The holes are in the areas where this defendant pointed and shot at the victim, and they went through his body. That's what the photographs show. That's what the evidence shows. That's why they were admitted into evidence. To corroborate the fact that this defendant murdered Mr. Wright, not to waste your time, not to just for fun, to put exhibits in, but to show you all of the evidence, to show you all of the facts, to give everything to you to utilize and to use when you go back into the deliberation room, so you can make the decision that this defendant is guilty beyond a reasonable doubt. Now, I want to talk to you about some evidence. And as you've heard, the evidence is in the form of witness testimony, physical evidence, the science, which is through Dr. Baird and Ms. Holman, and then the defendant's own actions, his admissions, and his lies. His actions before the shooting, his actions during the shooting, and his actions after the shooting. And you've heard from Mr. Forte, Mrs. Forte, and Ms. Parks, and I won't rehash or reiterate what they said, but you heard all of the information that we talked about. You tripping, he tried me as soon as the shooting had occurred. The testimony about the victim's firearm, when you don't see it on the video, and when you do see it on the video, corroborates what Mr. Forte says. Then you have be a closing without a technology issue. Yeah. Then you have the testimony of Miss Forte that she called the police after seeing her son and who she called a CT on the news, that he came to her house. She testified that he came to her house unannounced with her son or without her son after the shooting. That was her testimony. And that's when he told her what he told her. And she said that could sound like self-defense. And his reply was, no, I shot him 6 times. And that's when, as Ms. Jones-Connor pointed out, she said, oh shit. And he left and she didn't see him again. Then you heard from Ms. Parks. And what I will highlight as it relates to Ms. Parks is, again, she said that the defendant told her street did it. You got the physical evidence. We'll start with the video surveillance, which you've seen over and over again. The video surveillance, again, corroborates Mr. Forte, corroborates the fact that the defendant is the aggressor, that the defendant is the person who initiated the contact with Mr. Wright, not the other way around, that he continued the argument because he was disrespected and he'd been tried, and that the person who introduced a firearm into the argument is the defendant, not the victim. And again, the press contact room, and as we talked about, or we said earlier, that the video evidence corroborates the fact that the victim did not brandish, point, touch his firearm before he was shot. Here you have Mr. Wright before the shooting. 7. This is 4 minutes after. Mother, child, Miss James is left. You don't see a firearm in his waistband. You see him walking down the hallway. looking straight ahead. And who pops up? You don't see Mr. Wright knock on his door. No testimony or evidence that Mr. Wright screaming Mr. Tuitt's name. He's just walking to the stairs. Who stays in his space, who continues to follow him? The defendant. Again, in the picture to the right, you see the pink firearm. This is Mr. Wright coming back in his apartment at 1:33. Corroborates what Mr. Forte said. The gun has been moved. Then you see Mr. Wright again and his firearm. It's a little dark, but if you watch the video, surveillance footage, still in his waistband, exactly where you see it at 1:33, and that's at 1:45 as he's entering back into the apartment complex, the front gate of Building 2000. Well, you saw it in the last video, again, that this defendant is the individual who initiated, started the contact that led to what occurred on August 7th of 2022, that led to Mr. Wright being shot and killed after being shot 6 times all over his body at close range. I want you to watch Mr. Tuitt. See Mr. Tuitt's arm, his left arm, the arm that you always see the gun after the shooting, raises up. Don't see a gun from Mr. Wright yet. What is Mr. Wright doing? He's turning to walk away. Still see that left arm bent and extended. Use your common sense, ladies and gentlemen. No gun seen from Mr. Wright. You can see his hands. Who is exhibiting the aggressive body language? Not Mr. Wright, the defendant. She wants you to not believe your own eyes. Defense counsel wants you to not believe what you can see in the video. She wants you to make up evidence. You still don't see a gun from Mr. Wright. Still can see Mr. Wright's hands. The defendant has pulled a firearm. The only time you see a gun come from anywhere near Mr. Wright is after this defendant has pointed a firearm at him multiple times. After this defendant pulls that firearm again. And let's think about if you're in fear, if you're scared for your life, use your common sense. I know I keep saying that, but it's an important tool. Do you run back to the person that you believe is about to seriously harm you? Do you run back to the person who you think is about to kill you? No. Your common sense says no. He ran back to where Mr. Wright lay there and took something off of his body. I will say, I can agree with Ms. Fagan. I don't know what he took. He took it and fled. He wasn't caught or arrested a month later. I have no idea. What I can tell you is that in the area of where he is found or where Mr. Wright laid is the money that was laying kind of in between his legs. I submit to you that he took some of the cash from his pocket because he had cash in his pocket. But in all candor, I have no idea what this defendant took from Mr. Wright, why he went back over to where Mr. Wright was that he was so fearful of, other than the fact that, and you'll see in a second, he goes back there initially to shoot him in the back. And how do we know that one of the last shots is the back shot? Because you can see the position of Mr. Wright, and you heard from Dr. Baer that it's a close range shot, which the evidence shows he shoots in the back at close range. Then the scene, I won't belabor the point, victim is found shot 6 times. Coincidentally, there's 6 shell casings found in the area of where this Mr. Wright laid, bleeding and dead. The victim's gun is found near his body, and it's determined he never once fired a shot. You saw on the video, doesn't pull that gun. And again, he's got that press contact wound, which corroborates the evidence. You heard from Detective Sidley that when the medical examiners and investigators arrived and began to process and photograph the body, that when they turned him, there was a shell casing found underneath him. That's because he was shot at close range and fell on that shell casing from that muzzle imprint embedded shot into his chest. Again, you heard from the medical examiner, Dr. Baer. Again, 6 gunshot wounds to Mr. Wright. And Ms. Fagan is correct. I'm going to say 6 gunshot wounds over and over and over again. Why? Because that's the evidence. The evidence is that Mr. Wright was shot 6 times. And I'm saying that over and over and over again because 6 shots is not self-defense. 6 shots is overkill. 6 shots is excessive force. If you were to believe that the defendant was initially acting in self-defense, but he wasn't. He was tried and he finished the job. Again, the victim was struck multiple times throughout his torso, many of which were close range shots to the back. Is one of them. Did a close range shot to the hand. Again, the close range shots that were talked about by the medical examiner, Dr. Baer. This is after the defendant, the victim is laying, and you can see he's laying on his stomach. This is his back. It's the left side of his back where he was shot. And lo and behold, you see him, the gun extended pretty close to the body of Mr. Wright. I submit to you, that's the shot that was fired into the back of this victim as he lay there. And that's why Dr. Baer was able to determine that that shot was done at close range because of right there. Then another shot to the left side as he, after he's taken something from the body of Mr. Wright and is running along with Mr. Forte. And what's interesting, and I won't show on the video, but I know you all paid attention. As Mr. Forte runs, he drops 2 things. He drops something in front of and close to the door of 2303, which if you watch closely and you zoom in, you'll have that capability in the back. As you deliberate, it's a clip that Mr. Forte drops in front of the door of where CT and Ms. Parks live. And then as he continues to run, and defense counsel wanted to imply during the testimony of witnesses and during the trial, drops a lighter, that smoke, drops a lighter that's shaped like a gun. The lighter's dropped by Mr. Forte. Not smoke, but Mr. Forte. Again, trying to continuously mislead you to not have you look at the facts and the evidence that is right before your eyes, ladies and gentlemen. And why is she doing that? Why is defense counsel trying to distract you from what the facts and the evidence is and to provide you with things that aren't true, that didn't happen? Because she knows her client's guilty beyond a reasonable doubt of every single count of the indictment. Again, you heard from Ms. Holman. I won't reiterate. Glock 9mm is all you need to remember, not the gun of Mr. Wright, not that pink 9mm gun that belonged to Ms. James. Now, I want to end talking to you about the defendant's own actions and words and why that's important. I want you to focus on, again, what you did hear, what you saw, and what the actions of this defendant were, and what you didn't hear from this defendant when he had the opportunity to speak to Detective Johnson and when he spoke to others about this incident. Before, again, his actions were he was the one who initiated the contact. He was the one that followed Mr. Wright to the stairs, not the other way around. During, you saw the body language of this defendant. He was the one that second time they began to speak after Mr. Wright and Mr. Tuitt came up the stairs before the shooting. He's the one who's moving closer. He's the one waving his hands in Mr. Wright's face. He's the one that pulls the gun from his back pocket. And then his actions after. He fled the scene immediately. He never returned to his apartment. He blamed the shooting on the street when he spoke to Ms. Parks. He lied to the detectives about his role. He lied to the detectives about everything. Because he believed that because that camera above where he lived didn't work, that she was lying to him, that there was no camera footage, which is why he kept doubling down saying, I don't know why I'm here. I don't know why I'm charged. You heard that. I never saw the victim that day. The only time I saw the victim was after I opened the door from hearing shots and he lay bleeding near my apartment. That's it. Flight or fleeing, lies, and fear of accountability, which is why he lies, are not the hallmarks of self-defense, are not what is required for you to find that this defendant acted because he was so fearful that he was about to receive serious bodily injury or experience death, like Mr. Wright did. His actions after the shooting, don't forget the weed. Evidence of press contact wound. His shoes are soaked in the victim's blood. Again, continues to flee from the scene of the shooting. That defense wants you to believe was in self-defense. Ladies and gentlemen, people who act in self-defense don't leave the scene. People who act in self-defense, who do leave the scene, stay close by so they can get help immediately from the officers who are in the parking lot. That's what people who act in self-defense do. People who act in self-defense tell anyone that they acted in self-defense. They don't blame it on others. Remember, Ms. James said, as they passed the car, I want you to pay attention to Mr. Forte as he turns and looks and points. Remember, she said that one of the males yelled that it was just fireworks that went off, corroborating the things that Ms. James said and testified to each and every one of you. as they casually walk through the parking lot from building 2,000 to 1,000, knowing that the police are around. So trying not to draw attention to themselves, trying not to draw attention to the murder he just committed. So he can escape accountability for his actions. For the 6 times he pulled the trigger, leaving Mr. Wright to bleed out on the cold concrete of that 3rd floor breezeway. And as they cross Pierce Road, closer towards Donnelly Hollow, as Mr. Forte said in corroborating, they ended up at that point is when they went their separate ways. Again, the defendant's own words were not that he tried to kill me, I was in fear for my life, I thought I was gonna die, he tried me, I shot him 6 times, the street did it. You heard from Mr. Forte of the threats he received after he stopped answering the phone for this defendant, how he was called a snitch, how he was sent rat emojis and what he told you that meant. And all that was an attempt to intimidate Mr. Forte, to prevent him from sitting in that seat like he did the other day, to prevent him from looking each and every one of you in the eyes and telling you what he heard, what he saw, and what he remembered. And I agree with Ms. Fagan. He didn't see the video surveillance before he testified. He told you he didn't need to. He said, I was there. I was there. His memory, his observations, what he heard, what he saw that day, he clearly could never forget. And he told you nothing was going to keep him from telling you, because he wasn't going down for what he did for those 6 pulls of that trigger. Despite being threatened, despite his mother being threatened, despite being called a snitch, despite the emojis with the rats that continued after he stopped communicating with the defendant. And again, the defendant's own words to the detectives, his opportunity after he is arrested, after he has read Miranda, after he agrees to voluntarily give a statement, thinking that he could outsmart Detective Johnson because he knew that video surveillance camera above his apartment that would have directly captured the incident, directly captured him. Putting the muzzle of that gun into Mr. Wright's chest didn't work. So we told her that he woke up, heard shots, saw the dead body, fled, doubled down, even though Detective Johnson, as she said, kept it 100 and said she had the camera footage. Again, pay attention when you're back at the deliberation. Discuss what you didn't hear. Discuss what you didn't hear makes this clear. This is not self-defense. Self-defense fails when the defendant is the aggressor of the conflict, which you saw. He initiates all of the communication with Mr. Wright. He uses excessive force. He attempts to fabricate fear in front of each and every one of you through his lies. That didn't stop when he was talking to Detective Johnson. That continued during the course of this trial. This wasn't about self-defense. This wasn't about protecting himself from being shot, killed. This was about an execution. There's no other way to put it. When you put a muzzle of a gun into someone's chest, that you then pull the trigger, and that bullet goes through the heart, the lungs, every major organ in Mr. Wright's body, that is murder. That is an execution. And he didn't stop there. He continued to pull the trigger. Unjustifiably, from shot number 1. That's the facts. That is the evidence, ladies and gentlemen. What the evidence is, what you didn't hear is Mr. Wright didn't threaten anyone. He engaged in an argument. Mr. Wright never brandished his firearm. How do you know that? You all have eyes. And Mr. Wright couldn't run. Mr. Wright at all times was somehow backed in at any point or any time during that argument by Mr. Forte and the defendant. He was outnumbered. And because he didn't run, he died where he stood. This defendant fired 6 shots. Those 6 shots tell one truth. And that's this defendant is guilty beyond a reasonable doubt for every single count in that indictment. This defendant illegally possessed a firearm and then he used it because he was tried, because he was disrespected in front of his homeboy. And Mr. Wright paid the ultimate price. Mr. Wright will never get to see his son grow up. He will never get to experience another Christmas with his family, with his mother, with his sisters, with his grandmother, because this defendant was tried. He took the life of Mr. Wright and he took the future with his family because of disrespect. Ladies and gentlemen, the only verdict that speaks the truth is that this defendant is guilty beyond a reasonable doubt. And when you go back there and you deliberate and discuss the evidence and you come back out with a verdict of guilty beyond a reasonable doubt, you will not be telling the defendant anything he doesn't already know. How do you know that? It's because he lied. He's tried to escape accountability, and today is the day he is held accountable. He's held accountable by your guilty verdict as to each count in this indictment. Thank you.
Thank you, Mr. Abadi. Ladies and gentlemen, I'm going to give you the called the jury charge or the law in just a minute. Move your arms around a bit as I get it up on the screen. There it is. So a couple things about what I'm about to share with you. One, probably most important, you'll have this document with you during your deliberations. You're welcome to take notes, but I am reading more or less verbatim from this. This is the law that you have to give, that I have to give you, that you must apply to the facts as you find them to be. And if I vary by a the or an it's not intentional, but the substance of this document is the law that you must apply. You'll have it with you. Two, as I'm reading it to you out loud, the words will be up on the screen. Some people like to follow along. It's great. You can look up there. You don't need to look up there. It's the same thing as what is on this paper. Three, there are some turns of phrase in the charge I have to give you that are going to seem kind of stilted and overly formal, and I apologize for that. I try to make the jury charge accessible so that everyone understands what the law is. You need to, because you're applying it to the evidence. But I'll be saying a few things like abandoned and malignant heart. It's not how we normally speak. It's actually what's in the criminal code. That is one of the definitions of one of the elements of murder. And so when I use those kinds of words, that's not me trying to be fancy with a 25-cent word. It's actually how the law is defined. So bear with me as I bear with that, but I get reversed by an appellate court if I don't use certain language that's set forth in the law. That's how our legislators wrote it in the 1800s, and that's how we say it now. With that, ladies and gentlemen, I can get my PowerPoint to go. There we go. A grand jury has indicted the defendant, Mr. Tuitt, for murder, felony murder, aggravated assault, possession of a firearm during the commission of a felony, possession of a firearm by a convicted felon, and use of a firearm by a convicted felon during the commission of a felony. You'll have the indictment with you. Again, I promised you at the beginning, the promise is still true. All that charging language is in the document I'm holding, and you'll have that document with you. And to this indictment, the defendant has entered a plea of not guilty. It's actually got his signature on here. It says not guilty. Neither the indictment nor the plea of not guilty is evidence. As I have told you many times, because it's one of the most important fundamental concepts of criminal proceedings in Georgia and throughout the US, the defendant is presumed innocent. This presumption remains with him until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of one or more of the crimes charged. The state must prove every material allegation of the indictment and every element of each crime charged beyond a reasonable doubt. And in the charge that I'm giving you are these elements at long last. What are the pieces of each of these allegations, of these crimes? There's no burden of proof upon the defendant, and the burden never shifts to him. The defendant presents a defense. The state must disprove that defense beyond a reasonable doubt. The state is not, however, required to prove the defendant's guilt beyond all doubt or to some mathematical certainty. A reasonable doubt means just what it says. It's a doubt based upon common sense and reason. It's the doubt of a fair-minded, impartial juror, it's each of you, honestly seeking the truth. It is not a vague or arbitrary doubt, but is rather a doubt for which a reason can be given. And that reason arises from your careful consideration of the evidence or lack of evidence or conflicts in the evidence. If after evaluating the evidence, you find that your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law and you must acquit. But if such doubt does not exist as to the defendant's guilt, you would be authorized to convict. Evidence that merely places upon the defendant grave suspicion of the crimes charged or merely raises speculation about the defendant's guilt is not sufficient to authorize a conviction. It is my responsibility to instruct you on the law. That's what I'm doing right now. You are bound by these instructions. It is your responsibility to determine the facts from all the evidence you have received. You must then apply the law I'm giving you to the facts that you find to see if the state has met its burden. You must decide this case based only on the evidence presented here during trial. That evidence consists of all the testimony you've heard, all the exhibits that have been admitted. Evidence does not include the indictment or plea of not guilty, anything said by me or the lawyers to include their opening and closing statements, nor does it include any questions posed. And I flagged that one in particular because, of course, when a lawyer asks a question, whatever the lawyer said is not evidence. You all posed questions, and a handful of those questions may not have been asked. That is an unremarkable situation. It just means that it was not a legally proper question. You should draw no factual conclusions from the fact that maybe your question didn't get asked. Evidence may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact. We typically call these people eyewitnesses. I saw the blue car run the red light and hit the pedestrian. I was right there. I saw it. Direct evidence. Circumstantial evidence is proof of one or more facts that tend to prove some other fact by inference. I wasn't quite at the intersection. I heard some screeches of tires and then a thud with a car. Maybe that's circumstantial evidence that a car hit someone in that intersection. There is no legal difference in the weight you may give to direct or circumstantial evidence. And in considering all the evidence in this case, you may use reasoning and common sense to make deductions and reach conclusions. However, you may only convict if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the defendant's guilt beyond a reasonable doubt. You determine the credibility or believability of all the witnesses who testified before you. In deciding this, you may consider the evidence, the witness's manner of testifying, their basis for knowing the things about which they testified, the probability or improbability of their testimony, and their interest or lack of interest in the outcome of the case. The credibility of a witness may be attacked by disproving facts to which the witness testified. If a witness's credibility has been attacked, you may consider evidence offered to support the credibility of that witness. Your assessment of a witness's credibility may also be affected by comparing that witness's testimony here to statements that he or she made before trial. You must decide whether there is a reasonable explanation for any inconsistency between a witness's pretrial statements and trial testimony. You heard from several expert witnesses in this case: coroner, firearms person, and a couple others. Experts are those who, because of their training and experience, they possess knowledge in a particular field that is typically not known to the average person. Experts are permitted to give their opinions based upon that training and experience. The testimony of a single witness is sufficient to establish a fact. Corroboration of a witness is not required, provided you find the witness's testimony to be sufficient. A defendant who has no burden to prove anything is not obligated to testify. When, as here, a defendant chooses not to testify, you may not consider that decision in any way in reaching your verdict. Some evidence is admitted for sometimes evidence is admitted for a limited purpose, and that's happened here. In this case, 2 felony convictions of the defendant, I think it's 140 and 141, have been admitted. You may consider these only insofar as they may prove an element of count 7 and or 8, and for no other reason. And you may ultimately, during your deliberations, only get one of those because of the way the lawyers have agreed we can write these jury charges. But regardless, you received evidence that Mr. Tuitt has 2 prior felony convictions. The only way that you factor those into what you're working through as jurors is, do they prove elements of being a convicted felon in count 7 and count 8, and for no other reason? The state must prove the identity of the person who committed the crimes charged beyond a reasonable doubt. Your determination of identity is dependent upon the strength of the evidence offered for this purpose. A crime occurs when the law is violated by a defendant's intentional action. Intent is an essential element of every crime. Criminal intent is not the intent to violate the law, but is simply the intent to do the thing that happens to be illegal. Intent may be inferred from the evidence. It may also be inferred when it is the natural and necessary consequence of an act. The defendant is not presumed to have acted with criminal intent, but you may find this intent, or the absence of it, from consideration of words, conduct, demeanor, motive, and other circumstances connected with the acts for which the defendant is being prosecuted. Criminal cases must be tried in the county in which the crimes were committed. This question of venue, that is, where the alleged crimes committed here in Fulton County, must be proved by the state beyond a reasonable doubt. Here come the elements. Murder. For murder, the state must prove that the defendant, number 1, caused the death of another person, 2, unlawfully, and 3, with malice aforethought. The killing must have been done with malice to be murder. Malice, as that word is used here, does not necessarily mean ill will or hatred. Rather, it is simply the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with a deliberate intention to unlawfully take the life of another. You may also find malice when there does not appear to be significant provocation, and the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, that is, with unlawful intent, it is murder regardless of how briefly that malicious or unlawful intent existed. No specific length of time is required for malice or unlawful intent to arise in the defendant's mind. This malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act that killed, and it moved him to do it, that is enough for the killing to be murder. Proof of motive is not an element of the crime of murder. I told you what the 3 elements were. None of them was motive. Evidence of motive, if any, has been admitted for you to determine whether it establishes the defendant's state of mind at the time of the killing. Counts 2 through 4 all charge felony murder. For felony murder, the state must prove that the defendant, number 1, caused the death of another person, and number 2, by committing some other felony. The state does not have to show that the defendant acted with malice, i.e. this unlawful intent to kill, in order to prove felony murder. Aggravated assault, possession of a firearm by a convicted felon, and the use of a firearm by a convicted felon during the commission of a felony, so 3 charges in the indictment, those are all felonies. You may find the defendant guilty of felony murder if you believe that he caused the death of another by committing one of these 3 felonies: aggravated assault, possession of a firearm by a convicted felon, or use of a firearm by a convicted felon during the commission of a felony, regardless of whether the defendant intended the death to occur. There must, however, be some causal connection between that felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when that death ultimately occurred. Count 5 is aggravated assault. A person commits an assault when he attempts to commit a violent injury to another. A person commits an aggravated assault when he assaults another with a deadly weapon. And a firearm is a deadly weapon. Possession of a firearm during commission of a felony, which is count 6, the title of the felony pretty much defines it. Person commits the offense of possession of a firearm during the commission of a felony when he possesses a firearm during the commission of a felony. Murder, felony murder, and aggravated assault are all felonies, and firearm includes any handgun. Possession of a firearm by a convicted felon, count 7. For possession of a firearm by a convicted felon, the state must prove that the defendant possessed a firearm after having been convicted of a felony. And firearm, again, includes any handgun. And finally, count 8, use of a firearm by a convicted felon during commission of a felony. For this offense, as it is charged in count 8, the state must prove that the defendant, number 1, had on his person or within arm's reach, number 2, a firearm, number 3, during the commission of a felony against another person, number 4, after having been convicted of a qualifying felony. Firearm, again, includes any handgun. Murder, felony murder, and aggravated assault are all felonies against another person. It's element 3. And defendant's conviction from Fulton County that is set forth in count 8 is a qualifying felony. Sometimes a defendant's use of force is legally justified and so is not a crime. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury only when, number 1, he reasonably believes that the use of such force is necessary, 2, to prevent death or serious bodily injury to himself. The state has the burden of proving beyond a reasonable doubt that the defendant's actions in this case were not justified. If you decide that the defendant's actions were justified, it would be your duty to acquit him, to find him not guilty. For a defendant's use of force to be justified, the defendant must have believed that his use of force was necessary. And that belief must have been reasonable. That is, a reasonable person would also have believed that the use of force is necessary. And finally, that reasonable belief must have been what prompted the defendant to use the force. A person who is not the aggressor is not required to retreat before being justified in using the force he reasonably believes to be necessary. A defendant's use of deadly force may be justified even when there has not been physical contact between anyone. If the menacing action of the alleged victim is sufficient to create a reasonable belief that the defendant's life is in imminent danger, then the defendant's use of deadly force may be justified. Words alone, however, never justify the use of deadly force, no matter how abusive or provoking. However, verbal threats accompanied by some menacing action may justify deadly force. If you find that the defendant used force in self-defense, but that the force used exceeded what the defendant could reasonably believe was necessary to defend himself, the killing would not be justified. Ladies and gentlemen, you should consider each count in the indictment individually. The defendant may be found guilty of some, all, or none of the charges. If, after considering the evidence, together with this charge, it's almost done, you should unanimously find, beyond a reasonable doubt, that the defendant did commit here in Fulton County any of the crimes charged in the indictment, you would be authorized to find him guilty. And in that event, on this verdict form, in that event, the form of your verdict would be, we, the jury, find the defendant guilty. And you would check that option on the verdict form for that offense. If you do not believe that the defendant is guilty of a particular offense, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit him, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. And you would check that option on the verdict form for that offense. Whatever your verdict is for a particular count, it must be unanimous, meaning you all agree. Your verdict must also be in writing, signed by your foreperson, and dated. Here's a little preview. That's what it looks like for count one. We find the defendant, and if you're unanimous and you find the defendant is guilty, you check guilty. If it's unanimous that he's not guilty, you check not guilty. If it's not unanimous, you don't check anything. By no ruling or comment that I have made during the trial have I intended to express any opinion about the credibility of the witnesses, the evidence, or the possible guilt of the defendants. Your verdict must be based solely on your consideration of the evidence according to the law I've provided you in this charge. It's your duty to consider the facts objectively, without favor, affection, or sympathy for anyone. It is also your duty to report to me if you perceive that a juror is making decisions based upon improper considerations of race, gender, religion, or sexual orientation. You are the fact finders in this case. You are not to concern yourselves with punishment. That is a role for the judge. One of your first jobs in the jury room will be to select a foreperson who will preside over your deliberations and who will sign this verdict form to which all of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with your fellow jurors and a careful consideration of the evidence. During your deliberations, you must not communicate with anyone outside your group about this case, nor may you conduct any research. You have all the evidence in this case. It would be improper to supplement it with any outside information. And to assist you in complying with these instructions and prevent a mistrial, Deputy Gordon will be collecting all of your electronic devices during your deliberations. Apple Watch, iPad, phone, anything that connects you with the outside world, you cough it up, you give to Deputy Gordon, we keep it back in chambers, we hear them beep all afternoon. When we're done for the day, I promise you get them back, but not while you're there in the jury room. From here on out, if you need to communicate with me for any reason, it must be in writing. Upon receipt of your question or note or whatever it is, I'll confer with the lawyers and with Mr. Tuitt, and I'll share with you whatever response I am allowed by law to give. And I put that last phrase in there for a reason. You may have a great question, and my answer may be, you got to figure that one out. There are only certain things that I can share with you once you're in your deliberations. A common question is, hey, could we have the testimony of witness X? And my response will be, we don't have transcripts of witness X. You'll have to rely upon your collective recollection. But if it is appropriate for me to answer, I will do so in the way that I think is most helpful. So questions, you write them down, you let Deputy Gordon know, he gets them to us. And with that, ladies and gentlemen, I'm done with the charge. I'm going to ask all 13 of you in just a moment to arise, take your pads with you. Once you are back there, you can select your foreperson. And as soon as the evidence makes it back to you all, and that evidence will include with it the indictment, which is not evidence, and the verdict form, and the jury charge. Once you get all that, you can start your deliberations. Before then, just sort of get situated and comfortable and all that. But then you will be underway, and I'm told lunch will be here in about 35, 40 minutes. So we haven't forgotten about that. If a juror takes a break, everyone takes a break. You cannot, may not discuss the case with only some of you there. So if someone says, you know what, this has been heavy, I need to walk down the hallway for 3 minutes, then everyone is taking a 3-minute break. You don't all have to walk down the hallway, but all of you need to be in the room when you're talking about the case. If you will please go with Deputy Gordon, I will be back with you in just a second.
All right, to the jury.
All right, you all can be seated. So we need to sort out our alternate. Juror 26, we released Monday morning. Hopefully she is just selling all sorts of vitamin water now. That meant that juror 37 became a non-alternate juror, and juror 40 is structurally, the way we picked the jury, our alternate. I now want to hear from both sides. None of these jurors know any of this. Whether juror 5 should be the alternate, and we have her be in the alternate space, and juror 40 is one of the deliberating jurors. Does the state have a perspective on that?
Yes, Your Honor, and I understand my perspective is one, also it's in the discretion of Your Honor. But the state's perspective is that it should be juror number 40 that is a participating juror instead of juror number 5. And I make that observation or request because of the fact some of the things that juror number 5 said when she came back in, and her focus was on not being able to make a decision. I think her exact words were on somebody's life and things of that nature, which we didn't get to explore really ad nauseum as we would have during the voir dire process and during jury selection. And because of that, I think she would be the most appropriate individual to be considered an alternate. She was able to make it through the process, but after lunch when she came back, her biggest concern was no longer just having to sit through the trial, but ultimately the anxiety that she was feeling and she described was, having to deliberate and make the decision, and her exact words on somebody's life.
Okay, and just to add to that, and the record, it's already in the record, but all of this is on a foundation of active mental health treatment that she didn't bring up during voir dire, but then she and her mother brought up directly to my staff when she was told she had been selected. And then we all engaged with her on Monday morning about that. And she even brought in some paperwork documenting that she's been receiving treatment. And my concern is simply this: we get partway through and then we learn that she's shut down. We got to put juror 40 in there anyway, and then they have to restart their deliberations. And so it seems like a more prudent way to approach it. But I am interested just as much in your input, Ms. Fagan.
We agree.
Okay. Well then, Deputy Gordon, if you would get juror number 5, please. Hey there. Juror 5, you are our alternate juror. So I'm going to have Deputy Gordon show you to a different, will it be the other jury room or somewhere else? Through that door that has what looks like a cyclone on it is a whole nother jury room. And I'm gonna have you be there when the food arrives. You're gonna reunite with your friends. to get lunch. But we always have one, ideally two, and we had two, but we had to excuse someone, alternate jurors, because you never know when we might lose a juror because of illness, conflict, et cetera. You've heard all the same evidence as everyone else. You are not, however, going to have to go through deliberations right now. Should we need to excuse one of those 12, then they have to restart their deliberations and you'll be joining them and will become a deliberating juror. I'm going to ask that you stay with us today as long as they deliberate. If for some reason we don't get a verdict today, then we'll have a conversation about whether you would prefer to be at home or basically not here, but you could be on call. Because if deliberations continue tomorrow and at 10 a.m. we have to excuse juror X, then we'll need you to be down here. And it's okay for you to stay away until we need you, as long as you could get here pretty quickly. If it's going to take an hour, we don't have that kind of time. But as I said, if they reach a verdict today, then they and you will have completed your jury service, but we do need you to stay around. If you have electronic devices or a book or anything like that, you will be free to use those during your quiet time, as long as you aren't doing any research about the case. Anything else that's going on in your life, you're free to pursue digitally. You just need to not look anything up or do anything in connection with the case. We'll keep you posted. If there is a verdict, once that's taken, we'll bring you in, and I'll excuse all the jurors together. Do you have any questions about that?
I do not.
Okay. Were you hoping to participate in the group lunch? Because you also, if you don't like pizza, you'd be like, go get your own lunch. But you were meant to be part of that. The alternate always was. And so we can let you know when the food gets here. But that's entirely up to you.
I brought my own lunch.
Okay. Well, then you can eat your own lunch whenever you want. I don't know that there's a fridge in there, so you may just want to get everything that's yours from that jury room. Deputy Gordon will get you in there. And then, like I said, I promise there's also their restrooms in there. So you are self-sufficient. I promise you're not going to open it at 7 and say, where'd everyone go? We will keep you posted. Okay. If you ever need anything, poke your head out. I'm one of the deputies. Will help you out. I have calendars this afternoon, so we'll be in business and it's not a problem for you to open the door and say, hey, the light went out or whatever the situation is. Okay.
Gotcha.
Thank you.
You want to do it?
But you guys look at the. Do you have the thumb drive?
So the actual evidence, it has everything on it, and it's just that. I can combine, that's the only.
Well, we'll talk about it in just a second. So it can be wherever. We actually upload it onto the computer and take the thumb drive out. So it's a closed universe. But I want to make sure that whatever we usually just drag and drop everything, but Mr. Tuitt's interview cannot be in that universe. So does the thumb drive have everything, or it has everything but his interview?
So it doesn't have an interview, so it's on a separate thumb drive.
Okay.
I did this trial where I have each one of the thumb drives only has, so one, like the states of 5 only has the video surveillance, all of it. And then the only other one that would go back is the Ring camera stuff, and it's just got the Ring camera on it.
Okay.
So I can put them both on one. Or
No. So it's just, we could pull everything off states 5, or wherever the 2 are. You can show Deputy Gordon. He will get the stuff so it's available for them to do whatever they're going to do in terms of reviewing video. If they want to see the statement again, they need to send a note. That happens out here in front of all of us. So as long as you show Deputy Gordon what those 2 thumb drives are. And in that vein, have you and Ms. Fagan discussed about what goes and doesn't go back with the jury?
We did, and I think we're in agreement that everything goes back with the exception of State's Exhibit 141, which is the certified conviction for count 8, and then the defendant's statement, which is we just discussed.
So I'd ask that the statement go back. They can't play it, but that way they have it. So that may remind them, oh, wait, what's this? It's his statement. So I typically have all the digital stuff go back. They don't get to plug stuff in and do it. There's a keyboard, not even a mouse, it's a keyboard with an annoying finger pad. And so their universe is defined by what we put on this. This thing is stuck behind the monitor, and that'll be just the videos. So please do send back whatever piece of media Mr. Tuitt's statement is on, so that they have that as a reminder that that's out there.
It would just be 141.
Okay. And you agree with that, Ms. Fagan?
Yes, sir.
Okay. Ms. Fagan, any exceptions to the charge?
No, Your Honor.
Mr. Abadi?
No, Your Honor.
The verdict form, since you're standing right here, Mr. Abadi, is pretty standard, but if you would look at it and then Ms. Fagan could look at it.
No.
Ms. Fagan, did you have any concerns about the verdict form?
No, Your
Mr.
Honor.
Abadi, okay with the verdict form?
Yes, Your Honor.
Okay. Then I'm going to have Deputy Gordon take the evidence back to the jury. They'll begin their deliberations. If I could, on this note card, have a phone number for Ms. Fagan and one for the state. No matter what number it is, it will just get a prosecutor here. You're welcome to stay in the courtroom at 1:30. We've got more criminal calendars. Mr. Tuitt, we will bring you out here anytime something's going on with your case. If there's a juror question, you get to hear what it is and hear the discussions about what the answer is going to be. Obviously, if there's a verdict, you'll be out here. Otherwise, you'll be back in the holding area until there is something from the jury.
Okay.
Okay? All right. Thank you, everyone.
Then 140.
Are they good? They're great. Okay. 141. Yeah. That goes. Thank you.
And Your Honor, will the courtroom be open the whole time?
Yes. Nine one two.
Thank you.
All right, we have a final plea and probation revocation calendar this afternoon. We took care of a whole lot of the final plea calendar last week. Thank you, everyone. We've got a little bit left. Deputy Gordon has asked that we start with Ms. Alexander's situation. So we can sort. And we have a jury deliberating, so if they have a question, we have to pause what we're doing or a verdict. How are you?
I'm fine, how are you doing?
You're observing or you have a case?
Doing good well.
Okay, well, welcome to the team.
Thank you so much.
Judge Barwick is sad.
I know.
She'll be strong. She's retiring anyway, so. Ms. Wood, can you give me the case number, please?
Yes, Judge.
Oh.
25.
They know where you.
Sorry. 25 SC 000941.
All right, thank you.
What's that? Slide over.
All right, so Ms. Alexander, you were supposed to be here on the 25th and you weren't, so I signed a warrant. You're here now, which is good. And Ms. Wood told me she was gonna spend some time talking with the prosecutor to see if the case could be worked out. I think that's not what's happening today, but I'll hear from Ms. Wood in a second. If that's not what's happening today, then we need to sort out what to do with this warrant. So Ms. Wood, you can get started.
Yes, Judge. I have spoken with Ms. Alexander. It's my understanding she wants to move forward to a trial date.
Okay, which is of course what she had on the 25th of September.
Yes, Judge. So I would be asking the court, if possible, if we could add it on to the October 16th trial calendar.
Okay,
So yes, and of course, I'll keep speaking with Ms. Davis and Ms. Alexander between now and then.
okay. Anything about why Ms. Alexander was not here for trial last time?
Your Honor, I'll let her share with the court. I'm not sure. It was my understanding before I left town, that everyone understood that Mr. Dobbs or Ms. Rios would be filling in for me on the 25th, and that everyone would be joining here to see what would happen with their cases.
Which did happen with all your clients, except one. Okay. Ms. Alexander, why don't you tell me, what was going on that prevented you from being here, the day we were going to, maybe start your trial on the 25th of September?
I had no notification,
Really?
really.
Okay. You're saying that Ms. Wood didn't tell you you needed?
I
to be-
have a cell phone number. I have an email address.
Yeah. Do you live in Austell?
I don't currently reside at that address.
When did you move?
I've been evicted
I'm sorry to hear that. When did that happen?
in April.
In April?
April of 2025, yes.
Okay. So we had you here in court in April, and you showed up for that. We had a final plea date in August. You were here for that. How are you knowing that it was time to come to court for those things?
I've been contacting Lacey several times. I've been trying to keep in contact with her.
Okay. Do you have a stable place to stay now?
Yes,
And where's that?
in my cousin's house.
Okay. Let me check a couple other things. Ms. Davis, one other thing, I guess we should, the final plea rights for Ms. Alexander had been preserved to the trial calendar, but here we are. So I think I want to cover that part now. So let me ask a few other questions. Ms. Wood, do you feel like you've got all the discovery in the case, given that you're asking the case to be put on a trial calendar? We're calling next week.
Yes, Judge.
Okay. Ms. Davis, what is the state's offer? It sounds like you and Ms. Wood talked about resolving it today. What did you offer?
Judge Alger was 10 years to serve 10 weekends, balance on probation, an anti-theft course, for her to forfeit the firearm that was used in this offense, for her to complete her GED if she has not already, 60 hours community service, no contact with the victim, Mr. Becker Red Sear, and to stay away from Jessica.
Was your understanding from a review of the file that Ms. Alexander knew the victim, or was this a stranger on stranger situation?
It was a stranger on stranger.
Okay,
Yeah, it just seemed to be an incident that occurred because situational.
Okay.
She worked at the location.
she did or he did?
He did.
He did. Was this walking up to the cash register saying, give me what you got, or?
It was, I need to use the restroom, took money out his pocket. There's a tussle for the money. Somehow he has her phone, goes to return it, and then a gun is discharged.
Okay. Ms. Alexander, those are just the allegations. I'm not taking that as proof of anything. I'm just trying to understand the framework of your case. Do you understand what it is that the state was offering you in this case?
No, I don't understand because I was never,
Okay, so we'll talk about it real briefly. Well, I want to preface everything I'm about to say by saying you don't need to plead to anything. I'm sharing this with you not to apply any pressure at all. If what you want is your day, and it would be a few days in court where the state has to prove it up, you're entirely entitled to that. And you have an excellent lawyer who would represent you zealously at that trial. If instead you wanted to work the case out, what the state is offering is 10 weekends in custody. That wouldn't start, it might start this weekend, although it's Thursday, it would probably start at the next weekend. So for 2 days, Friday, Saturday, Sunday, each week for 10 weeks, you would be in custody. You'd be released on Sunday. When that was done, what would be left would be a bunch of years of probation. And then there are a few things you need to do while you're on probation besides staying out of trouble. Complete a class, do some community service. If you don't have your GED yet, you get your GED. You may have
I'm a licensed state of Georgia cosmetology student from Chattahoochee Tech, sir.
So you finished high school.
I do. I finished high school, North Atlanta High School, class of 2001.
All right. Well, I've got a class
And
of,
I would like to have some type of, something I could do to reinstate my license because it's been delayed since I've been in this,
your cosmetology license?
yes, I haven't been able to renew my license.
Okay. I don't know how that process works, and I
Yeah,
don't,
I understand.
I don't know if, and I didn't mean to suggest you didn't have a PhD. If you didn't have a GED, that was one of the conditions, but you know what? I can cross that one off because you're an NAHS grad, so you don't need to worry about that, and you're a licensed or semi-licensed cosmetologist. I don't know how that works if you end up pleading to this case or going to trial and being convicted.
Oh, okay. So what am I pleading towards? What charges are you all charging me with?
So your indictment charges you with robbery and aggravated assault and having a firearm in connection with what you heard Ms. Davis just talk about. So there was some incident. I'll pop this up on my screen. In February of last year, so not this February, previous February,
What year?
2024, that would be last year.
No. What year for 2024? What were the charges?
So the allegation is that on Valentine's Day, that'd be February 14th.
2024, right?
Correct.
Correct.
Yeah.
Okay. You said
Valentine's-
2004. That's what I heard you say.
2024.
Last year, correct?
Yes, ma'am. Last year. Not this year, but last year, and not
Yes.
2004.
And not 2004 because today is 2025.
Right. So if I misspoke, apologize. Valentine's Day of last year, it's alleged that you took some money from Mr. Nasir.
I was given the money.
Okay, so here's what we're not gonna do is have a
Okay.
back and forth. I don't know what happened. And
and the
stop. Just let me talk for a little bit and I'm gonna let you talk, okay? Ms. Alexander, you asked what you were charged with. I'm telling you what you're charged with.
Yes,
That doesn't mean,
sir. I'm listening.
that doesn't, good, listen quietly. That doesn't mean that you did anything at all. It's an indictment. It's the way the state brings charges. You said, what would I be pleading to? You would be pleading to being involved with this supposed robbery of Mr. Nasir, having a gun. The gun was discharged. You weren't supposed to have a gun because you were under sentence out of Douglas County for a possession of drugs by an inmate conviction out of Douglas County. That's what you're charged with. Do you understand? I'm not asking if you agree with those charges. Do you understand what's in
I'll
them?
take a plea.
Okay.
I'll plead not guilty.
Okay, you are free to plead not guilty, and here's what's gonna flow from that. We're gonna add your case to the upcoming trial calendar, and you're gonna go with Deputy Gordon, and I'll make sure you are brought back here for the call of the trial calendar next Thursday.
Next Thursday.
Next Thursday, that's when we call the calendar, 2025. Thank you, Ms. Wood, for working on that case today. Let's call the final plea calendar. Position 1 is Sir Quentin Blount or Blunt. I apologize if I mispronounce your last name. Blunt? Okay. Why don't you come, well, before you come up, let me hear from, I'm sorry about your Bengals issue. It's not going well. What are we doing with Mr. Blunt today?
I think it's just a final plea hearing. I do have an offer, so it might resolve before trial, but just not today.
Okay, then come on up. We're gonna get a few things on the record, Mr. Blunt. And what calendar are these cases on? I can look.
I don't know.
Well, I'll look at this one at least. You can look, there are only a couple others that are left. No, this one's November. Yep. All right, let's get on the record here. This is 18 SC 158561, State versus Blunt. Mr. Blunt is here at the podium with his lawyer, Ms. Wood. Ms. Davis is here for the state. Mr. Blunt, today's your final plea date. What that means is today's the last day you could enter a plea if you wanted to. Of course, you don't have to enter a plea. And if I end up sentencing you to more probation, jail time, fine, whatever the state asked, whatever your lawyer asked, whatever Ms. Wood asked for, if I give you more, you can say no, thank you today. And with no questions asked, you go home and we'll just see you for your trial calendar, which is November 13th. So about a month from now, you'll be back here for the calendar. After today, you can still enter a plea. You're not locking yourself into trial. The difference is if a week from now or the day of the trial calendar, Ms. Wood says, hey, how about 2 years probation? And I say, no, given what I know about Mr. Blunt now, I think it should be 4 years probation. You're stuck. You don't get to withdraw your plea because you don't like your sentence. Today you can. After today, you cannot. Does that make sense?
Yes, I do.
Okay, if it doesn't, you made a face like it did not make sense, but you said the word yes.
Yes, it makes sense.
It makes sense. You may not like it, but it makes sense.
Yeah, right.
Got it. Okay. Ms. Wood, do you feel like you've got all the discovery in this case from 5 years ago?
Yes, sir.
Good. Ms. Davis, what is the offer if Mr. Blunt wanted to resolve the case today?
Judge, we would be null crossing the intent to distribute marijuana count and moving forward just one simple possession for cocaine, and it would be 5 years probation, drug and alcohol evaluation and treatment required, 60 hours community service, for him to complete his GED or provide proof of completion, and to stay away from the incident location.
All right. So as I'm hearing it, Mr. Blunt, it's a straight probation sentence. We figure out if you would benefit from any kind of drug treatment, alcohol abuse treatment, a little bit of community service. If you don't already have a high school diploma or equivalent, and you get that, and you stay away from wherever this situation happened. Is that how you understand it?
Yes, sir.
Okay. Is that something that you are interested pursuing today, or would you rather come back here on the 13th of November to go to trial on both counts? The state is, when you say no pricing, the two counts I have, one says cocaine, the other says marijuana.
I think I might have inverted them, so count 2, sorry, would be null crossed.
Okay,
Yes.
dismissing the marijuana with intent to distribute and going forward on the straight cocaine. Got it. Okay. So I feel like I understand what's going on. I need to know if you do and then what you want to do. Or if you need to talk with Ms. Wood a little bit more, you're free to do that. The pressure is only when you leave today, you will have told me either, no, thanks, I want to go to trial. You can still plead, you just don't get to withdraw your plea later on, or yeah, let's do this thing. Ms. Wood will argue for what she wants to, you know what the state's going to say, and we'll go from there. But if you need to talk to her more, that's fine. You want a little more time? All
We'll
right.
talk, Judge.
Sounds good. It'll be a quick follow-up conversation because now we know what all the parameters are. Thank you. Positions 2 through 5 have all resolved. How about Sean Hill?
Good afternoon, Your Honor. Melanie Elway here on that case. We do not have an offer yet and are asking to be placed on the motions count. Can you press that?
Why don't you two come to the podium, please? So in July of this year, I entered a scheduling order that set a deadline for motions, other than motions in limine, of August 11th. And then we would have heard any motions that were filed on September 9th. So walk me through we want a motions.
Yes, Your Honor.
Take.
We filed a plea and bar, an immunity motion in July and particularized it, we believe, enough where the state would be on notice on who to call. We did not receive discovery until the day before the September 9th motions hearing. We resubmitted that motion, further particularized after reviewing the discovery.
Okay, this thing called motion to dismiss the accusation, that is an immunity motion?
It is, Your Honor.
Got it. Gosh, it has legislative history in it. Is there?
Mr. Spiesman drafted it, so.
Okay. Okay. Immunity motion it is. We need to certainly work through that first. And I see you did get discovery late. But you have now been able to further particularize the immunity motion, and we need to get that on a calendar. Ms. Davis, will this be your case?
Yes, Judge, it will be.
Okay. Any reason discovery came late?
I'm not sure why discovery was late in this case, Judge, but when it was brought to our attention, we did make sure it was served. I did receive the immunity motions, though,
Okay,
and that was the hold on the offer.
got it. All right, I will work with Ms. Nelson about getting the immunity motion scheduled. Mr. Hill. I'm just looking at your bond. No bond, that's not how you get out. There's a bond.
Your Honor, you did set the bond and he's on an ankle monitor and had compliance earlier this
Good,
week.
that's what we're talking about. You're staying away from Ms. Zagaye? I
Yes.
don't know if I pronounced that.
Yeah,
correctly.
you did. Yes, Your Honor.
Okay, got your ankle monitor on, you're paying for it, but that 4 months is up in about a month.
Yes.
Okay. You're staying away from Lilburn,
Yes, Your Honor.
staying with your parents?
Yes, Your Honor.
Okay, all right. Ms. Davis, you may want to put a tickler in your system to check with the victim, because pursuant to the terms of the bond, the ankle monitor comes off in about a month. And that was a product of a good discussion we all had. And that's how it will be unless you bring something to me saying, that may be too soon because whatever. Okay. We'll get a date set for the immunity motion, and that'll be your next court appearance, Mr. Hill. You'll need to be here for that. One of your lawyers will be here for that. And I don't know if they've talked to you about it, but it's kind of a mini trial. There won't be a jury. I don't know whether you'll testify, but witnesses will be talking about whatever supposedly happened in this case.
Okay.
All right.
I understand.
Any questions?
No, Your Honor.
All right. Anything else on behalf of Mr. Hill?
No, Your Honor.
Ms. Davis?
No, Your Honor.
Okay, thank you.
Thank you, Your Honor. And that completes my business. May I be excused?
You both may.
Thank you.
And then we have Mr. Mendez Carranza. Is he in custody?
Yes.
Judge, we have a little bit of an issue.
Uh-oh, you always have, come on. What?
I know, Judge. I don't think, he's not here, right? Okay.
Oh, he's not here.
He was here, but.
Well, that would be an issue. Wait,
Well-
what?
Well, there's a separate issue, so.
He escaped?
No.
Nah.
In the chaos of my return to the office, I'm not sure if my interpreter request actually made it to the appropriate channels.
Okay,
And so then Deputy Gordon and I were speaking this morning about who could be going back. And so my fault.
okay,
That he is back at jail.
all right. And this will not be your case.
Yes, Judge.
Excellent. I think Ms. Clark had sent an email in connection with this. This is a case where there were DFAX records and you have had an opportunity to review them. Okay, so we've checked that box. So there ought not to, well, there aren't discovery concerns from my side, meaning we got you that. Any other discovery issues?
There was, and I'll forward the email that I had sent to Ms. Clark to you.
Thank you.
There was just, I had a question about some of the discovery I was given was not scanned in very clearly, and so I was just checking to see if there was a clearer copy.
Clearer copy.
Okay. And Judge, I would like to know his wife, the alleged victim in the case, and the other children are in the hallway as well. I've been keeping them out there, for decorum purposes.
Okay.
But I'm gonna let her know what's happening.
Okay. I'm remembering from looking at the DFAX records, it's his daughter who's the alleged victim. Well, there's a connection. It was a familial setting and supposedly a picture on a cell phone or something, and he gets beat up and all that. Okay, okay. So did you get an offer from Ms. Clark?
Yes.
Okay, and you didn't get to convey it because there was no interpreter?
Well, the last time I met with him, I kind of knew what the offer was going to be before I officially got it, so I explained this was just going to be a final hearing today.
Okay, because based on what you thought was coming, he was going to say no thanks to that.
Correct. There's also a hold that just popped up for stuff.
A hold from federal government?
Yes.
Okay, that may be dispositive of things. If they just hold, but if they grab, then that may be what happens. Okay. How familiar are you with the case?
I am, minimally.
Okay, and that's an okay answer today. I'm not about to quiz you on it or anything like that. Really where I was going was whether you had looked at the case enough to say, I respect my colleague's offer. You know, I've dived into the case a bit, and so Ms. Wood and I will talk because there might be a different outcome. And I don't know, and I don't ever mean to suggest you need to reevaluate things, but should Mr. Carranza stay in the United States and we move forward, obviously you'll be controlling the prosecution, and so you should feel free to say, here's a revised offer based on your assessment of the case file.
Understood.
So it sounds like we could move it to a trial calendar because Mr. Carranza wasn't gonna be saying yes anyway.
Correct.
All right, we'll do that. We, of course, are responsible, the court is, for producing interpreters at trial. I guess you are gonna have someone to assist you in communicating with them, because we also, for a hearing, something like this, we can get interpreters here.
Yes.
Okay, all right. Then I guess, we'll just, do you know what calendar he's on?
I'm so sorry, this week's.
He's on November. All right. And you'll want to get with Ms. Nelson to make sure you get the trial calendars. I can't remember if Ms. Clark had any, we have a trial calendar that we're calling next week that is at the end of October. Does she/you have any cases on that?
As I recall, I did look at that, probably there are 3 cases, right, on that one.
Okay. All right. Well, you got stuff to work on. What other courtrooms are you in?
I'm also in Judge Barwick's courtroom and Judge Schwab.
Okay. So at least 2 on the same floor. All right. So we will just move Mr. Carranza to trial. And I guess that's it for the calendar, other than we'll circle back to Mr. Blunt in a little bit. Let's talk briefly about the probation calendar, and then we'll make a plan. We've got Mr. Hassan with not 1 or 2, but 5 positions on there. Are we just looking at each other again? Like, yep, I'll see you in another month, Mr. Amar.
But there should be 3 additional.
Yeah.
Cases
8?
as well, yes.
Okay, does Ms. Nelson have those case numbers?
She does.
Okay. We probably ran out of paper. That's why-
I know, I did.
Yeah.
Yes.
Yes.
You wanna have a bit on this?
No, I think we're ready to go, but obviously moving to. You can't plead it, the plea we have. So.
Just, we just need a moment.
Yeah,
but
that's
we're
fine.
moving with all this.
You can talk in just a moment. Let me find out what we're doing with Mr. Wells. Is that also a problem?
Very not happy with me today.
No, I just was sort of taken aback by Ms. Alexander. My feelings are still hurt. Like, well, I was answering your question. You got snippy.
Now you know how
I am confident you get it worse than I do.
Judge, so, Mr. Wells, I did not realize when we were last with him, I knew he had that unindicted case. I didn't realize there was a co-defendant at the time, who has more cases with our office
Oh.
in Judge Carnicel's courtroom.
Okay.
So,
You shouldn't be handling Mr. Wells because you'd also be resolving, ideally, for him,
great,
a case where your office is handling the co-defendant.
correct. And I know Mr. Wells really wants to resolve the probation matters at the same time.
That's the case. Okay.
I don't know if this is something that goes to Judge Carnicel now, or if everything comes here.
The unindicted, I'm sorry, the case that he wants to resolve is indicted?
It is indicted.
And is it in Judge Carnicel's courtroom?
Yeah, it's not our courtroom, correct?
Okay,
Co-defendant case.
the co-defendant case, but the violations here aren't related to that. And so it can happen in one of 2 ways. We could handle this revocation now, or we could say, you know what, we're gonna table this and we'll just ask, and she'll say yes, but we'll ask Judge Carnicel to be sure. And it would be incumbent upon her probation officer in that courtroom to say, hey, Judge Carnicel, there's also this 12 SC case with a year remaining, or whatever's left, with a technical violation. That's probably the most efficient way to do it, rather than to pull from Judge Carnicel half of a case that you can't handle anyway.
Yes, Judge.
Okay,
That would be mine.
should I explain that to Mr. Wells?
Here.
You sent him home?
Yes, I'm gonna see him tomorrow, Judge.
Okay,
Yes.
then I don't need, great, he can yell at you, not me. All right. Ms. Simpson, anything else we need to do? I mean, this is one where I'll just let Judge Carnicel know, when you resolve all his other business, could you mind folding this in?
No, but to go back, this case actually is, this is for the revocation.
Oh.
In addition to the text.
Oh, is there another, because the warrant that I have signed in November of 23.
Yeah, you signed the petition that includes.
Oh, there's a newer petition.
Yeah.
Oh, then it definitely, and so it just goes to Carnicel. Done. All right.
Does she need
Excellent.
that case number?
The new case number? I don't need to bug her. If the petition has, the indicted case, then our policy is, she must handle the revocation. Yep. Pardon me? No. No, and his case, yeah, but this wasn't a drug court revocation. He'd already had that. Was it on?
Yes, correct.
Okay. And did his 12 SC go back home to whatever? Let's look. Ooh, green light. What does green light mean? They just miss you? Oh, so it's ours anyway. Of course, it's just down 400 years probation. Anyway, we're done with Mr. Wells. You should still see him tomorrow, but it would just be an adieu. And who would handle it in Judge Carnesale's courtroom?
Well, since we have the co-defendant.
Oh, no one,
Yes.
right, no one from your office would be, okay. So I think that leaves Mr. Hassan, and if you and Mr. Amar need to speak for a little bit, you can do that. And Ms. Wood, you could use that same window of time to talk with Mr. Blunt. I think those are our two remaining moving parts. It's an easy day for you, Ms. Williams.
Yes, Judge, thank you.
While you're here, before you pack up, let me see, I'm gonna get my hands on the oh, it's not there yet. I was gonna try to look at the trial calendar so I could just give you my sense of where it's gonna be. Bunch of cases have had to go away, which moves you up. If you have position 5, we may try that case. Do you have the calendar, or should I give you names of Gentle?
I have Gentle written down.
State needs to be ready to go on Gentle.
Okay.
All right, if you are prioritizing Gentle, maybe, unless it works out, I don't get the sense that the defense is gonna take anything other than a real serious apology from your office.
I will do those like once a month.
Yeah.
Dates already passed.
You've used them up, okay, well, Gentle would definitely be one you wanna be ready for. And where else do I see Ms. Clark's name? Bonilla Garcia, I don't know anything about it. His lawyer tends to work things out, so you're gonna wanna work with him. We'll need an interpreter for things, and of course, the day we call the calendar is not the day we start that, so next Thursday, we'll call on the calendar. But you ought to reach out to Mr. Wallace to see if that's a work-outable case.
Okay.
And
I also have Terry.
Jonathan Terry, that's your case?
I have it written down.
Okay, it says Ms. Davis, but it doesn't mean that,
Is
it's,
it ending 2370?
yeah, yeah. We may have resolved that case. Let me look. It sounds familiar.
Yeah, we did. We did that.
Yeah, he pled.
Oh, so yes.
Look at that. Boom. You just lost 33% of your caseload. Gentle's gonna be a handful, so be ready on that one, and then definitely speak with Mr. Wallace, counsel for Mr. Bonilla Garcia.
I believe I know Mr. Wallace. We've worked together before. So
Good.
I'm hoping.
All right.
I believe, do you have Zoom up right now?
Dude, it's on.
Okay, Ms. Rios is on with position 14, Ms. Joyner from this morning.
Okay. Ms. Rios, can you turn your camera on?
Hey,
Hey, how's things?
good.
Excellent.
How's y'all
So,
doing over there?
well, we were gonna make some progress. We'll see. We've got this poor gentleman with not now 5, but 8 cases, that we may be resolving today. It's taken like 9 people from, hold that thought. Deputy Gordon needs me. There's something with the jury.
Okay.
But it sounds like you have someone online.
Yeah, Miss Jones, I'm gonna go ahead and file a waiver on her. She qualifies, but I want her to go to the office to do official paperwork since she never was with us, but we're good with her.
Hold on, I'll be right
Okay.
back.
I'll just give her what was happening. Crayfish choke. Right.
No, I don't know where, do you know where Deputy Gordon, he just said I was supposed to talk to Deputy Gordon, but I don't see a Deputy Gordon. Maybe he's still with the jury. I'm not, I can't go in there.
But I'll still be around, so if you send me an email, I'll make sure to,
I haven't, but today when.
or if you send me an email,
I haven't, but today when I was looking, I was like, why you got invited on the case?
okay. So, whoever that is, I don't care for that, we're gonna just bring them up. Okay. You know what I mean? Okay. Okay, but yeah, if you know, have what you're gonna do, thank you. If you have something you wanna send me though, because there's not really point of contact yet, ask. Okay. Cool, thank you. I just wanna see if we can transfer it. Mr. Rivers, do you know Judge Center right back? Now, so, you think so? You don't think so? You think so? It seemed like he was. Okay, I printed off all these. Yeah, he's coming right back. I just know that I just Rivers, my name is Michelle. Really? Okay. I was trying to wait to see if Ms. Nelson's coming back. Oh, yeah, I'll be here starting next week. Oh.
All right, it would be good if we could do Mr. Hassan now, otherwise there may be a break for a while. Are you ready to go? Okay, well, while we're waiting on Ms. Davis, Ms. Rios, can you give me the case number you're talking about, please?
Yes, it is 25 SC 005515.
I don't have what? Was this from this morning?
Yes.
Oh, did she not show up?
No, she called and then you guys told her to hop on Zoom.
Okay, so we held off to, so I've got that calendar. Is she online or in person?
She's on the Zoom. Miss Jones, turn on your screen. Barbara Jones.
It's Joyner. Ms. Joyner, are you
Oh,
there?
Joner, sorry.
Yes, I'm here. Can y'all hear me?
We can hear you. I need to see you.
Okay. Can you see me now?
There you are. Excellent. Okay, so Ms. Joyner, you were on our plea and arraignment calendar. You did a good job of calling in, saying you were doing your best to get here. Ms. Rios, anything you want to add?
No, Your Honor, I'll get the waiver and she just needs to go to my office and do an official application since she was never represented by our office, but I'm sure I already gave her address, so she'll come up there soon.
Okay. Ms. Joyner, did you get something in the mail telling you needed to be here today?
I did.
Do you still live on Candler Road?
No. But
Okay.
I still get mail there.
Well, is there a better address for mail or is that a good address for mail?
That's a good address for mail.
Okay, is that apartment 1219?
Correct.
Okay. Let me check one other thing here. So your bond order is old, but it's still a good bond, meaning you got to comply with it. You're supposed to stay away from someone named Heather Webb. Are you doing that?
Yes.
Okay. And you're supposed to stay away from some address on Boulevard.
I don't go to Boulevard. I'm not from here. I'm from Virginia, so I don't be in Atlanta.
Are you in Virginia right now?
No, I'm in Georgia.
Okay. when you say you're from Virginia, like tomorrow you're gonna be back in Virginia, or you grew up in
No.
Virginia?
No, I'm stating that I don't know that area, that when the incident happened, I didn't even know where I was at then. And I
Okay,
don't be down there.
good, okay.
So
But you
yes, I
plan
will
on
be staying
staying
away
in
from it.
Georgia, you plan on staying in Georgia for a little bit?
Yes, I'm here.
Okay.
I have kids.
Okay, you just told me you're from Virginia. I'm just trying to sort out what you meant. It's all good. Okay. All right. So Ms. Rios is going to file some important paperwork on your behalf. You need to go meet with her. She told you where to be. So please meet with her and we'll move your case along. Okay.
Okay, and also, is she still on? I need her to send me the location.
Oh, I thought
Is
I
it-
did. I'm sorry. I'll text you the address right now.
Okay, thank you.
Does she have your phone number, Ms. Joyner?
Believe so.
What are the
Yes.
last four digits of your phone number?
3754.
Do you have that, Ms. Rios?
Yes.
Okay, she's going to text you. Make sure you keep Ms. Rios's phone number. That's going to be your best means of communication, okay?
Okay.
All right, Ms. Rios, anything else?
No, Your Honor. Thank you.
All right, will you let Ms. Nix know that Ms. Joyner appeared virtually with you? Ms. Nix was going to get me a bench warrant. She knew that I might not sign it because Ms. Joyner was doing her best to connect with us. And I just need someone to close the loop with Ms. Nix.
Will do.
Thank you. All right, you're good to go, Ms. Joyner.
Thank you.
You're welcome. All right, is Ms. Davis still, where'd the lawyers go? Have you all ever seen a verdict before? No? Well, we're gonna do that first because I don't know how long this is gonna take. And that'll let the jurors be on their way. I hope you guys have a little while because you'll be here for a bit. Okay. Can you call the prosecutors to have them be here, or at least one of them?
You mean Adam?
Adam.
Oh. Okay, all right. That's what we were hearing right coverage.
Deputy Gordon? Can we bring Mr. Tuitt out? Am I moving too fast? Is in our 4 backloaded cases? Lonzy? Yeah.
Okay, so does he fall under the role play? Because Lindsay, you said you signed it out. Do we need to do it?
No, we already did. We already did. So I signed the order. And so, Ms. Wood, when we're doing an ex parte evaluation situation, you are the one or someone in your office contacts, Ms. Green, Zarina Green?
Yes.
Okay, excellent. So you just let Ms. Wood know? Great. So just like we've always done it.
Okay.
Thank you. Yeah, I'm sorry. They were taking too long on this other stuff.
Yeah, no. So yeah, you just forward it to me and I'll.
Okay.
Just so that she.
Hey, I'll know you're ready when you bring them out.
How are you?
I just been. No, okay.
Ms. Davis, this Joel Lett case with the lawyer we can never get, he needs to plead to get into BHTC or it's a diversion into BHTC? Okay. All right. So we still need her. It sounds like there's some paperwork the attorney needs to sign, but then of course we need everyone to do the plea. Okay. Thank you. We got lots of people now. We good? Okay. Ms. Rivers, I'm gonna give you 141 back. All right, Ms. Rivers, you ready to get back on the record? We are on the record in State versus Tuitt. Mr. Tuitt is in court with his lawyer, Ms. Fagan. We've got both our prosecutors here. Deputy Gordon tells me the jury has reached a verdict, so I will bring them out in a moment to receive that verdict. I'll ask folks in the gallery, whatever that verdict is, absorb it quietly. If you don't think you can, please step outside and someone can let you know what that verdict was after we get through the process. Mr. Abadi, anything we need to talk about before the jury comes out? Ms. Fagan?
No.
And I do want to get on the record that Exhibit 141 stayed with me up here on the bench during the jury's deliberations. All the other exhibits did go out per lawyer agreement. With that, let's bring the jurors out, please. That's for this case with the immunity motion. It's a perfect time for just.
I couldn't see.
It doesn't say.
I thought it was.
They're supposed to send it. I know. That's how I saw when I looked in the doc. I'm like, there's no. What are you talking about? They need to send that to us anyway.
Bill, the president of the county court.
Thank you, Deputy Gordon. Everyone else, please be seated. Ladies and gentlemen, it's my understanding that you, as a jury, collectively have reached a unanimous verdict. And whoever the foreperson is should say yes or no.
Yes.
Yes. Okay. If you could give the verdict form to Deputy Gordon, please. All right. I'm going to ask you as the foreperson to please stand. Have you and your colleagues reached a verdict?
Yes.
Was that verdict unanimous?
Yes.
And have you as the foreperson filled in and signed the verdict form?
Yes.
I'm going to ask you to publish the verdict, which means read the verdict as to each count into the record.
Okay. So we, the jury, find the defendant for count 1, murder, guilty. We find the defendant for count 2, felony murder with aggravated assault, guilty. For count 3, felony murder with possession of firearm, so count 7, we find the defendant guilty. For count 4, felony murder, use of a firearm, count 8, we find the defendant guilty. Count 5, for aggravated assault, we find the defendant guilty. Count 6, possession of a firearm during commission of felony, we find the defendant guilty. Count 7, possession of a firearm by convicted felon, we find the defendant guilty. And count 8, use of a firearm by a convicted felon, we find the defendant guilty. So say we all this 9th day of October 2025.
Thank you. Deputy Gordon, if you would get the verdict form to one of the prosecutors and then to Ms. Fagan. Mr. Abadi, any objections to the form of the verdict? Ms. Fagan, any objection to the form of the verdict? Mr. Abadi, any reason I cannot excuse the jury? Anything further from the state?
Nothing further from the state.
Ms. Fagan?
Yeah.
All right, ladies and gentlemen, on behalf of the state as well as Mr. Tuitt and his lawyer, I want to thank you for your time. You gave us 4.5 days. We needed it. This was a case that required a cross-section of our community to listen carefully to the evidence, think about that evidence, and apply the law to the evidence that you received to reach the verdict that you did. I will take it from here with the litigants. I'm going to ask you to retire to the jury room. I'm going to have your alternate join you, and I'll come back and share a few more words, chat with you a little bit about the case, and then you will be released. But thank you on behalf of Fulton County writ large for your service.
All right, so jury.
So we're going to take a quick break, and then what normally I have jurors come back out here if they want to interact. I'll have the jurors stay in the jury room, those who want to interact with the lawyers, and you all can chat with them if you want to chat with them. We are doing sentencing today. I have a plea to take, and I think I'll probably take that first and then we'll do the sentencing, but I'm going to confer with Deputy Gordon about that. But immediately I need to get with the jurors so those who want to leave can leave, and then I'll let the lawyers know if any of them are interested in providing feedback, answering questions, that they'll do that there so I can move forward with the other matter while you chat with them, and then we can do sentencing. Anything else from the state as to Mr. Tuitt's case? Ms. Fagan?
I was going to request not to do sentencing today,
And for what reason?
to be able to have this family present.
Are they local so that they could be, it's only 2:30.
I can reach out.
Okay, why don't you do that and let me know? I don't want, if his family was going to provide something that I ought to hear, you're certainly entitled to present that. I am anxious to wrap things up, but only consistent with your right to present what you want to present during sentencing. So if during the break we're taking, you could reach out. If they can be here at 4, that's great. If the answer is they can't be here at all, and this is happening before you thought it was going to happen, then we'll do it tomorrow. Okay? All right. True. I talked with Ms. Fagan about that. I want to say this. I want to thank the lawyers on both sides. This was very efficiently tried, and as usual, mutual respect, which makes this process so much easier for the jurors because it's about the facts and the weaknesses and the strengths of the evidence, and not this lawyer is this way and that lawyer is that way. So you were very, very professional in your work. I'm confident the jurors appreciated that. I will be back in a few minutes. So Ms. Davis, with you sitting right there, that tells me that maybe we're ready on Mr. Hassan? Okay. And Mr. Blunt, is Ms. Wood still around? She's back there? Okay, when she comes back out, I'll figure out what we're doing with you, okay? All right. Can we bring Mr. Hassan out, please? You should go on back. No, not you. You should, if you want to chat with the jurors, you should go to the jury. Oh, is Mr. Hassan able to stand?
Yes.
For the whole plea?
Yes.
Okay. It is, that's why I was asking. I just couldn't remember. Hassan, please. Ms. Simpson, help me remember, if we go forward with the Tuitt. Ms. Fagan, did you have any luck reaching any people? What's our?
I did, but I'm not going to report that the court's going to be satisfied with.
It's not up to me. Tell me what the plan is.
I have one person that requested to speak on his behalf. I
Okay.
understand the recidivist statute that was filed, I've reviewed it. So I humbly request to do it in the morning, but I understand the.
Can you guys switch around? So this is someone you'd like to have in person rather than on Zoom?
Yes, sir.
Okay, and this person can be here tomorrow morning? All right, Mr. Body, can you be here tomorrow morning? Well, can someone from your office be here to handle the sentencing? Okay, why don't you check with them? Because we can always do a two-part sentencing as well and hear from everyone on Mr. Wright's side. So why don't you guys confer? All right, I need to get a lot of paper.
Yes.
We approach this around just on the same page. There's a lot of
Sure.
moving parts here. Make sure we're okay. So we expect results and we make sure.
So I have 5 cases on the calendar.
So there's 2 probation revocations, 3 2024 indictments, and 3 2025 accusations. I wrote it down.
Okay.
They're all 2025.
I think so, yeah.
I'm sorry.
Because we've got it.
That Excel spreadsheet was now.
Oh, good.
To you, Judge, I CC.
Yeah, I think we're
Done
on
as
yeah.
well.
You didn't send it to me.
I didn't send it to you because I try to keep your inbox easy.
Okay, well, I appreciate that.
Yeah, it's a spreadsheet, so it keeps track of the cases and the locations and the victims. And the order for actually. That's what it takes.
I can get it from Ms. Nelson if
I'll report to you right.
you'll send it. Thank you.
I'll put Deb on it so he knows.
All right, once I get the spreadsheet, we can get started.
I mean, triple list.
Got it. The spreadsheet is of the new cases?
Yes,
Okay,
and not the probation cases.
got it. So it's 6 new cases, 2 probation revocations. That's the 13 SC and the 24 SC.
Correct.
All right, got it. All right, Ms. Rivers, are you ready?
Yeah.
Okay, we're gonna go on the record in just a moment. Let me add. There we go, a camera. And we're gonna go on the record in the matters involving, what's your last name, sir?
Hassan.
It is Hassan. You're listed in a couple different ways just because sometimes they flip names around when you're getting booked in. We have Mr. Hassan here in court with one of his lawyers, Mr. Amar. We have Ms. Davis for the state. And it's my understanding, Mr. Hassan, that you are prepared to enter pleas in 6 cases. They are all new charges. Some of the conduct may have been a little while ago, but, and I think they are all second-degree burglaries.
Yes, Judge.
And at the same time, we'll be handling 2 revocations from some second-degree burglaries, one from long, long ago, 2013, and the other more recently in 2024. Is that your understanding?
Yes, sir.
Okay. For us to get through all that, you need to be put under oath. Ms. Davis will take care of that. She will be asking you questions about your cases and about your rights. You need to answer those truthfully and completely. You should feel free to ask for a break anytime you want to talk to Mr. Amar about something. You're welcome to ask me, but I need you to let me know if you, at some point, you ever get confused or need to talk to your lawyer. Will you do that?
Yes, sir.
Okay. Ms. Davis?
Please raise your right hand. Do you swear or affirm the testimony that you will give in this matter before the court shall be the whole truth and nothing but the truth?
I do.
Okay, you can put your hand now down. Please state your true, correct, and legal name.
Abdul Hakeem Hassan Jr.
Can you spell your first and last name?
ABDULHASAN.
At this time, are you under the influence of any alcohol, drugs, or medication?
No,
Is there any medication that you normally take that you have not taken today?
no.
How old are you and how far have you gone in school?
58 in 3 years of college.
Are you able to read, write, and understand the English language?
Yes,
Are you a United States citizen?
yes.
Do you understand that you're charged with the following offenses? Just you want me to just list out the accusation one time in this portion or just the last 3?
When you say the last 3, I'm not
I'm
sure what you
sorry,
mean.
indictment numbers and accusation numbers.
Oh, yeah, let's just do we haven't listed, I didn't list all the cases. So for this first time, if you'll go full board, 25 SC, but the rest of the way through, you can just say 450, 651.
Understood.
Thanks.
Okay. Mr. Hassan, do you understand that you're charged in indictment 25 SC 450, with burglary in the second degree, 2 counts, and possession of tools for the commission of a crime?
Yes,
Do you understand that you're charged in 25 SC 4651, 2 counts of burglary in the second degree?
yes,
You're charged in indictment 25 SC 4660, 2 counts of burglary in the second degree and theft by deception.
yes,
You're charged in accusation 25 SC 6228, burglary in the second degree, 2 counts.
yes,
In accusation 25 SC 6229, burglary in the second degree, 1 count.
yes,
And lastly, in accusation 25 SC 6230, burglary in the second degree, 1 count.
yes,
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
yes.
Have you had enough time to speak with your lawyer, Mr. Amar, about all the facts and circumstances known to you regarding the charges and the indictments and accusations, including any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No, not at this moment.
Are you satisfied with his services?
Yes,
Attorney Amar, do you waive formal reading of the indictment and accusations and any and all defects therein for the purposes of this plea, including his name being entered backwards in several of the indictments?
Inverted a few times. Yes, we waive those.
Mr. Hassan, do you remember being arrested on these charges?
yes, ma'am.
Your Honor, the state is unaware of any outstanding warrants related to this matter. I will say, just for the record, there was 1 warrant that was dismissed at the prelim. And so that's the only other one I know that's outstanding and lingering. Mr. Amar, are you aware of any outstanding warrants related to these cases?
Not to these cases, but I am aware of an out-of-state warrant.
Okay, understood.
When the warrant you're referring to, does that mean there is a set of Fulton County charges that we're not resolving today?
No, Your Honor, it was, some of these cases had multiple warrant numbers associated with them, and one of them, I'm not sure why, was dismissed at the preliminary hearing level.
Okay.
So just in case.
Got it. But you feel like,
And I filed it down.
okay, you feel like you've swept up all the open cases into various accusations or indictments?
Yes, sir.
Thank you.
Can I ask, has there been an MPTJ or no process on that unindicted case?
Well, it was a part of one of these cases.
I see.
And there was a dismissal order entered by the judge.
At the
for one.
prelim,
Mhm.
but not at the Superior Court level. Probably.
Correct.
All right. Well,
And I did no process and file it down.
They got it.
Okay.
Okay, that's what it is. Thank you.
Mr. Hassan, has your attorney advised you of the minimum and maximum sentence for each charge to which you are pleading to today?
Yes, yes.
Okay. For burglary in the second degree, because this is a second or subsequent charge, you're previously convicted of a burglary in the second degree. So that timeline is a minimum of 1 year and a maximum of 8 years.
Yes.
For possession of tools for the commission of a crime, it is a minimum of 1 year, a maximum of 5. And then for the theft by deception, it was indicted as a misdemeanor. So the maximum sentence would be 12 months.
Yes.
Do you understand that today you're entering a negotiated plea of guilty, which will mean the state will make a recommendation to the court?
Yes, ma'am.
Do you understand the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that there are multiple charges to which you are pleading to today, and the court has the right to sentence you consecutively or one after the other?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including federal courts?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And that's true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you'd be guilty of a felony, which can carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? And I'm going to go over 9 and then ask you, do you understand? Okay?
Yes, ma'am.
The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am. Honest.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have only 4 years from today for the felony charges and 12 months from today for the misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
How do you plead to the charges? In indictment number 450, burglary in the second degree, 2 counts, and possession of tools for the commission of a crime.
Guilty.
How do you plead in indictment 651, burglary in the second degree, 2 counts?
Guilty.
How do you plead in 660, burglary in the second degree, 2 counts, and theft by deception?
Guilty.
How do you plead in 228, burglary in the second degree, 2 counts?
Guilty, ma'am.
How do you plead to 229, burglary in the second degree, 1 count?
Guilty.
How do you plead to 230, burglary in the second degree, 1 count?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Your Honor, the state believes the evidence would show in indictment 450 that on
Do you mind closing the door to the jury room, please? Thank you.
that on December 3rd, 2023,
This is 450?
Yes, Judge.
Okay,
And there's two different dates in this indictment.
okay.
On December 3rd, 2022, officers were actually dispatched 2 days later to the location of 3525 Piedmont Road. There, they met with the caller, who was Michael Marr. Michael Marr owns a business at that address, the Marr Law Firm. And earlier that morning, he had noticed that some of his belongings were disturbed. There was an envelope that contained check stubs that was missing. Officer was able to review the security footage and saw that a black male wearing a gray hoodie entered that business. That individual was later identified as the defendant, Mr. Hassan. And Mr. Marr advised that there were at least 15 or so debit cards that were taken from the property as well. On June 2nd, 2023, at that same, building complex at 3565 Piedmont Road, and this is in 2023, there was again a report of a burglary at the location. Mr. Hurd was the caller that the officer spoke with, and he was able to, point out footage that identified Mr. Hassan. At this point, officers knew and were familiar with the individual because there had been several burglaries that were reported in the area. And Mr. Hassan did enter that facility with the intent to commit a theft. They are also able to review footage from that June 2nd date and see that Mr. Hassan had in his possession a screwdriver which he used to pry open several doors, and there was a dent in the screwdriver was actually bent. And so that is a tool that's commonly used to commit burglaries and break into properties. With indictment 651, the state believes the evidence would show that on December 9th, 2024, at the location of 6285 Barfield Road and 5901 Peachtree Dunwoody Road, and these are in Sandy Springs, Georgia, that officers were dispatched to these locations. Upon arrival, officers were able to meet with an individual who reported that the suspect, who they were now familiar with, which is the defendant, who had been involved in several commercial burglaries in the area, did follow behind a FedEx employee and entered that facility. It was at that time that Mr. Hassan stayed and hid out in the restroom until the building closed. And then they were able to observe him on CCTV, pulling on doors. He was able to enter the property of Quatera and Hosen. Those are two businesses. Quatera, Quarterra is a business, and Hosen, Hoisen, is also a business that has a suite in that facility. I believe it's the Palisades building. The defendant was able to take an iPad, some laptops from that location. And again, he was confirmed to be the defendant who had been frequenting the area. And 660 on November 11, 2024 at 400 Embassy Row. This is also in Sandy Springs. The defendant broke into several suites. Officers were dispatched to that location the following day. They were able to see that the defendant had broken into Tongue Tie Laser Center. He also reportedly broke into Donaldson Capital Management. From there, he was able to retrieve from those businesses laptops. Those same laptops were pawned at Value Pawn, and that location is 21 Decatur Street in Atlanta, Georgia. In 228, the defendant on November 15, 2024, did break into the property of 5909 Peachtree Dunwoody Road in Sandy Springs. There, he was able to break into Sago, S-A-G-O, which is a business, and Centerfact, S-Y-N-E-R-F-A-C, also a business. Officers were dispatched to that location in reference to several burglaries in that office building. They watched surveillance footage, again, able to observe and identify Mr. Hassan as the individual who had broken into those office suites as he was captured on CCTV. In 229, on December 5th, 2024, at that very same location, 5909 Peachtree Dunwoody Road in Sandy Springs, the defendant did break into the office suite of Gannett, G-A-N-N-E-T-T. Officers reported to a burglary call. There they met with an employee of Gannett. He explained that, of course, they saw him on the surveillance cameras about in the early morning hours. And he disconnected and stole 3 laptops. And lastly, Judge, in 230 on November 27, 2024, the defendant did go on the property of 5901 Peachtree Dunwoody Road in Sandy Springs, Georgia, and again vandalized the property of Hosen, H-I-O-S-S-E-N. And officers were able to identify the defendant because they saw him on surveillance footage and were familiar with the defendant.
Did he just keep bonding out, or there was just a big bolo for Mr. Hassan as Sandy Springs collected more and more video surveillance saying, that's the same guy, we can't catch him, but these are the same addresses he's going to.
Yes, and that's my understanding of it, because the way the cases were created and the warrants were entered, they entered all of the warrants on every case. And so it seems like they're being familiar, they know exactly who this person is, and then that last time they were able to capture Mr. Hassan and then
Okay.
associate him with all these cases.
Okay.
The state's recommendation. We are in lieu of a plea to all of these cases and his probation hearing. We are withdrawing our recidivist notice. And we are asking for the defendant to be sentenced to 8 years, to serve 2 years of that in custody. The balance of that to be probated, for him to complete an anti-theft course, to stay away from all incident locations. And I'm tempted to say Sandy Springs and just in general, but
Right.
definitely those buildings, those office facilities, to have no contact with the victims, which I don't expect him to, their companies, and for him to complete 60 hours community service and no further violations of the law.
So maybe Mr. Amar is going to get to this. Something's going on in Mr. Hassan's life that he is a serial, emphasis on serial burglar. He's breaking into place after place after place. And this sentence says you go to jail for a little while, take an anti-theft course, but then he'll go to in theory, could go to another office complex that's just not in Sandy Springs. Is there something more that's been brought to your attention that we could address so that an outside observer might think something other than why wouldn't he revert to his former ways after he gets out?
Yes, and Judge, as you know, we've spent a lot of time with the Georgia Justice Project. With this case, they have submitted his application to accountability court several times. I even went internally in my office to see if he could be eligible, but based on the number of cases, they weren't willing to allow him in accountability court. And
Okay.
also there is an outstanding warrant, I believe, in Alabama.
Oh, this is the foreign warrant. Okay.
And so I'm not sure if that's what's holding him back. I'll let Mr. Amar share a little bit more personal about what is going on, but he may benefit from some of the DOC programming that I've heard you mention in the past, so that he can kind of redirect his life.
Okay. Good afternoon, Ms. Jackson. Thank you for joining us. Do you have information about Mr. Hassan's criminal history?
Yes, good afternoon, Your Honor. There are 41 cycles. The last arrest was October the 11th, 2024, out of North Carolina for a chartered financial institution and from an institution in forgery. There was no disposition for the arrest. The only probation that was listed in the GCIC was the one for 24 SC 003123 for burglary in the second degree. That disposition date was August the 23rd, 2024, and the term is for 5 years. He does have prior felony convictions, one in 2021 out of DeKalb County for burglary in the second degree, one in 2017 for possession of Schedule 1 or 2 with the intent to distribute, one in 2014 for 2 counts of burglary in the second degree and 2 counts of theft by taking, one in 2008 for 3 counts of burglary, one in 2006 for 2 counts of burglary, one in 2003 out of DeKalb County for burglary and theft by taking, an additional one in 2003 out of DeKalb County for theft by receiving stolen property. It's another one in 2003 for possession of controlled substance, one in 2002 for theft by receiving stolen property, and forgery in the first degree, and it was 3 counts of forgery in the first degree, and financial or transaction card fraud, one in 1999 out of DeKalb County for financial or transaction card theft and forgery in the first degree, one misdemeanor conviction that was listed in 2021 out of DeKalb County for theft by shoplifting. Nothing in addition, Your Honor. Sorry.
That's all right. That was plenty. I appreciate that.
Yes, sir.
Mr. Amar.
All right, good afternoon, Judge. First of all, we're hoping, I know we haven't breached it yet, but I want to make sure that he still has 2 open probation cases, and I think the understanding is that all this will run together, and I don't know if the court's waiting to hear from probation officer independently of that. And I don't know how the court likes to merge those together, but I don't want to.
Well, what I do like to get from Ms. Simpson is how much time remains. So why don't we get that out there?
Okay.
Ms. Simpson, in the 13 SC case, how much time remains?
6 years, 4 months, and 1 day.
All right. And the 24 SC?
3 years, 10 months, 13 days.
Okay. Got it. And that 24 SC case, that was a kind of August of 24 sentence, something like that. I think that's what Ms. Jackson said. So Mr. Hassan was sentenced in August of 24 to however much it was. Here we are now. And since then, he picked up a bunch of the cases we're resolving. Okay.
So, Judge, we have been working with Mr. Hassan for a while, and the plan or hope was to get Mr. Hassan into treatment. So I think the underlying factor that the judge sort of referenced, alluded to, or intimated is his addiction. I mean, he's had an addiction problem. He's served in the Navy for a number of years. He came out of that after serving for, I believe, 4 years, and I think his addiction started pretty soon after that. One of the things we worked on and tried to do, and he's worked very hard to try to arrange treatment on his own. Our team, our social workers, our lawyers have also tried to arrange treatment. And actually, he got accepted into Hope House at a 60-day window from July to basically September, which is now over. But just we were hoping to maybe put that on the table early, but that we missed that window, and Ms. Davis knows, but that there's been efforts to look around at treatment programs. We've had a number of conversations, as well as Mr. Hassan has tried through the jail to get into the jail's program. There's a in-house program there. He's also worked with a number of folks at the jail to look at treatment programs outside. So treatment, and he's only, I should say, so treatment is the issue for him, and the addiction is the issue. It's a mental health issue that really, all these cases are all property cases or drug cases that relate to his addiction.
When you say he's tried to get into treatment courses in the jail, that tried, but it didn't work. He's been in almost a year.
Yeah, we submitted request after request after request, even talked with her. She said, hold on. She just did never accept it. I don't know why. She never did, never said why.
She didn't explain why. Okay.
And even our efforts in dealing with some of the jail folk said that Mr. Hassan had to ask personally. We tried to go around they said he's got to ask. He asked the best we could tell. So my only point here isn't whether they accepted him or not. It's just that we want to identify the issue and the issue that both our office as well as Mr. Hassan has been trying to deal with. I should also add that he's only really sort of touched treatment, if you will, in these 20 years or almost 25 years of addiction and engagement with the legal system a couple times. And one of them was through this court where he went through accountability court. It was 8 years ago, and went through the veterans program into a program where he stayed for a couple weeks, and it didn't, he left, it didn't work then. He had a teeny bit of other involvement, but he hasn't really been into serious treatment, or the one serious attempt did not fail. I mean, he admits it, he wasn't ready. He's written a letter, I think I shared with Ms. Davis, as well as the accountability court folk, that he acknowledges his failure then, and he wants to try again. He wrote that letter, months ago, as an effort to sort of explain where he's at and the effort to try to open up the door for further treatment. So, as you know, we kept hoping that the accountability court would accept him, or that at least we could arrange an outside program that would be acceptable to the court. At the same time, he's willing to take accountability for all the things where he's at and the things he's done. And he's willing to take this plea, but I would also add, Judge, as you know, we will stay with Mr. Hassan into prison and afterwards. And one of our social workers is here, who's worked with him, Xandria Redding. Happy if the court wants to hear from her a bit, but we're not giving up on him no matter what happens. But I think he knows he needs treatment, and that's what we hope, and that's what we're going to keep trying to provide for him, whether it's today or it's in 2 years from now. So, Xandria, you can go ahead. Come on, Xandria.
While she's coming up, I have a question for Ms. Simpson. Well, I think I know the answer. There's ample time left on probation to get Mr. Hassan some custodial drug treatment through DCS, but we've got all these other cases, and if there were an equivalent amount of custodial time there, he'd really be doing GDC time and not DCS time. Is that right?
Based off of if we were moving forward with the recommended sentence, yes.
When you say the recommended sentence, meaning what Ms. Davis said?
Yes.
Well, let me give you a hypothetical. I say revoke X years, and that's more than enough time for Mr. Hassan to be on the wait list and then get into DCS's RSAT.
I said you would, hypothetically, it would be a time served.
And then he's in RSAT.
Yes.
Right, but so I revoke X so he can get in there, but I know how long that is, and so what I also do is sentence him to X on these new cases, so that he has in parallel this revocation that would be sending him to RSAT, but also a sentence that would be sending him to the Department of Corrections. Which road does he go down?
The new case would, I believe, because the two would need to match, because you can either go one way or the other.
Right.
So either it's a time served and the rest is on probation and then you go to our program.
Right.
Or it's a custodial time and then you go to PDC.
Okay. All right, I'll probably circle back to that. Tell me about Mr. Hassan's treatment or what you've been helping him with.
Mr. Hassan has made treatment relatively easy for me as a social worker. Like Mr. Amar said, he has been reaching out to programs. We've been meeting, doing some general counseling, encouraging him to stay sober while he is in custody. But most of the work he's kind of done on his own. He's been trying to reach out to facilities. I have facilities call me before I get a chance to reach out to them to let me know that Mr. Hassan is interested. I've had counselors in the jail reach out to me and let me know Mr. Hassan is interested in programs that they have also assisted with researching for him. So,
Why do you think Mr. Hassan struggles to be admitted to these programs? He's knocked on so many doors and it sounds like none has opened for him.
well, with treatment in general, it's difficult to get into a lot of the programs. And it wasn't an issue with him getting in the program. I think initially when he was accepted into Hope House, there was that window where we were waiting on court. And so his acceptance into that program expired.
Okay.
He also wants something a little more structured like accountability court. And so we were pushing, trying to get into accountability court and then got denied. So I don't think it was an issue of difficulty in getting in a program. I think it was an issue of timing and alignment.
Okay, got it. Well, I appreciate you working with him and it sounds like he would be an ideal client because he's doing a lot of the legwork for you. All right, thank you.
One other piece I want to add is we got a letter today. Pat has also been working with him. Given, I guess that was based on his release from the cases from Married Life. We got a letter this morning from one of their counselors or social workers. So they've been trying to inject themselves to be supportive to his path to treatment and recovery.
Okay. Mr. Hassan, you were in the Navy when?
From 85 to 91.
All right, long time ago. Thank you for your service. Were you honorably discharged or dishonorably discharged? You did your time and moved on to other things.
Yes, sir.
What is your connection to the Atlanta area?
My family's here. I'm from here. I've been a part of the VA, been trying to get in treatment with them as well, because a lot of veterans suffer from PTSD. And I've been diagnosed with PTSD. And
From your time in the Navy?
definitely,
Were you deployed overseas?
yes,
Were you on a boat always or on a ship?
yeah, correct, Carrie.
Okay, and what type of traumatic events happened on an aircraft carrier?
Just a lot of injuries from aircraft, personnel getting injured on aircraft. So I was a
Okay.
medic, so.
You were the medic, so you were encountering these people who had suffered these injuries.
Yes.
Understood. Okay. Again, thank you for your service. So this is your native space. You didn't come here after you left the Navy. You were here before and you're back here.
Yes,
Do you have kids?
no, sir.
All right. Are there other things you want me to understand about your situation?
Yes, sir. I definitely would like to get into treatment. And, the PTSD side, I haven't really, I was working with a doctor there. He left. And he was making headways with me. So
A doctor where?
at the VA,
At the VA.
right, for the PTSD, he left. So I think I need to get back connected with that. I want to get back connected with it, find another doctor that was helping me. And that's where I'm at now. And that's where I want to be.
Okay. What do you struggle with the most in terms of addiction? What substance or product?
Cocaine and alcohol.
Cocaine and alcohol?
Yes.
All right. Anything else you want to share?
I think the Hope House would be a good fit for me because there are a lot of veterans there. And the guy that came and interviewed me at the jail, he's a veteran. He said, I could help you get into treatment because they have a good treatment program for his PTSD as well, getting connected back into the VA with the right doctors there.
You were in our Veterans Court for a while. How long were you in Veterans Court?
I stayed there 4 months.
Who was the judge you worked with?
Newkirk.
Judge Newkirk. And it ended because?
Staff conflict, staff personality conflict. It was a staff member that I had a personality conflict with. We didn't see eye to eye.
And
I discharged.
you walked away from Veterans
I
Court.
asked Judge Newkirk to take me out of it, so I wouldn't keep getting conflict with that staff member there.
Okay. All right. Anything else?
Like I said, the Hope House I think will be a good fit because like the guy said, he's a veteran and he could help me get connected with a lot of the doctors there for his housing, jobs, stability there. That's what I really need.
Got it. Hope House is your preference.
Yes.
Mr. Amar, what do you know about this foreign warrant?
So I've been in touch with the folks in Alabama. He's been assigned a lawyer, sorta. There's been some weird paperwork issues over there. It's a very small case. It's a forgery case. There's a co-defendant who already pled out to, time served. It was I talked to that person's lawyer. I talked to, I think, his assigned lawyer. We were trying, the goal I was hoping is that we could get a production order while we were waiting here to take him over there.
Right.
Because the case is much smaller and, do a concurrent sentence, whatever would happen here. That hasn't happened. I haven't had any more contact with his lawyer, Ms. Shelby Scott in Alabama. This is in Anniston. But I think that's still the hope is that, because I would hate for him, whatever happens here, I think there's still a hope that we can go resolve that while this is pending and him come back and serve whatever he needs to serve here.
Is the alleged conduct more recent or less recent than the cases we're dealing with?
It's concurrent. I think it's the same. I think it's November from 24. It shows all these cases, if you notice, are all within a month period.
Month or two, that's right. After he was on probation for a case from here. There's a North Carolina arrest.
I believe we looked into that. I think Jenny Hurwitz, I think that's no longer an issue, but I can tell.
Right.
I think we resolved that, and I should know exactly how it resolved, but I think it's no longer.
Okay, but you're not aware of there maybe being a hook then coming from a third state?
That's correct. And my understanding is that got resolved, however it got resolved, probably before July.
Okay, either way, it's not something hanging over Mr. Hassan's head. Mr. Hassan, you told me that you are a Georgia native-ish. Where in Georgia? If I'm thinking about saying you need to stay out of certain places, I don't want to exclude you from where a parent or a sibling might be, but I am interested in having you not be anywhere near North Fulton County. But that may be home base, and yet you're in Alabama and you're North Carolina. Where's home?
Right here in Atlanta, right here.
Atlanta's big. What?
The southeast Atlanta.
Okay.
Southeast Atlanta.
And who from your family is still in the Atlanta area?
My 3 brothers and my sisters here, cousins, nieces and nephews.
Okay. Your brothers live where?
Decatur and part of Atlanta, southeast Atlanta.
Okay. And I think you said sister. Where does your sister live?
She lives in Decatur as well.
Okay. Sounds like you got a lot of DeKalb family locations.
Mainly, yes, sir.
Okay. All right. Any other questions? I've heard about Hope House. Anything else?
That's it.
Okay. Mr. Hassan, well, I'm gonna I'll just ask directly of Ms. Davis. Why did the state think withdrawing the recidivist notice was appropriate? I'm trying to figure out the way you introduced it was, in light of the pleas, we're withdrawing our recidivist notice.
That was a part of our negotiations, Judge, and I will say this has morphed into something else. I think when we first started, it was like 2 cases.
Okay, but you had committed then to withdrawing it,
If
and
it
you
was a-
didn't renege on that.
2 years, yes.
Okay, all right. Mr. Hassan, I find that there is a factual basis for your pleas in each of these cases. They all have a certain similarity. You had an MO, you were feeding an addiction. It was the way it sounds like you probably put food on the table and alcohol in your glass and cocaine in your system. And getting you treatment is probably one of the 2 most important things that comes out of that. The other is we leave Sandy Springs alone. And in particular, this implant place that you hit twice doesn't need to worry about their laptops rolling away anymore. So I am focused on lifting you up, but I am also focused on a community that might say, wait, what? He's just out and about again? I don't think that's appropriate. I think that I need to structure a sentence where you will receive treatment before you'd be in a position to walk away from treatment and perhaps relapse. Your addiction is strong and it grips you clearly very strongly because you're not a young guy. You're even older than I am. It just, when Ms. Jackson was rattling it off, 03, 08, 14, 17, 21, you've been at it for a long time. And it can't be healthy on the inside. And it's dangerous on the outside. You may break into the wrong place and someone levels a shotgun at you. And this is Georgia. They can shoot you for coming in their property. And I laugh, but it's serious. And that wouldn't be what your brothers or your sister want to have happen. So, like I said, I find there's a factual basis. I also find that your pleas are knowing and voluntary. Voluntary means no one's forcing you to enter these pleas. You've been anxious for a while to resolve these cases. Knowing means you've understood everything. Any questions about anything we discussed? Pardon me?
No, sir.
No? Okay. All right. So, Mr. Hassan, there's got to be restitution, but it sounds like that's not anything being pursued at this time.
No, Judge, we just asked to reserve it.
Okay. All that means, Mr. Hassan, is that if Ms. Davis suddenly has lots of free time, which she won't, she could try to figure out what did these laptops cost? And if these different businesses that you burgled could show the laptops cost $100 or $1,000 and they could document it, that's restitution you owe. But I think everyone's being pretty realistic. Despite being a prolific burglar, you probably don't have $100,000 in your bank account to pay these people back for the damage that you did. Mr. Amar, can someone in my office sign the 6 indictments or accusations to which Mr. Hassan is pleading? For you, sign your name.
Yes.
You seem
No,
troubled by
you
that.
said someone in your, you mean the side, I'm sorry. I missed maybe it was a 6, but that got me, because there are so many.
There are 6 pleas and we're doing 2 revocations.
Sorry.
No signatures needed for the revocations. I'll do that. But for each of the formal charging documents, in the olden days, we hand things around, sign.
Yes, you have my.
Great. And Ms. Davis, we can sign for you?
Yes, Judge.
Mr. Hassan, can we electronically sign your name to the 6 documents indicating your guilty pleas?
Yes, sir.
Okay, good. Here's how we'll do this. I will go first on the calendar, 25 SC 000450, 2 counts of burglary in the 2nd degree, 1 possession of tools for commission of a crime. Your sentence as to count 1 and count 2 will be 4 years. Count 3 will run consecutive and will be 5 years. Counts 1 and 2 are in custody. Count 3 is probation. In 25 SC 004651, your sentence on count 1 will be 4 years. Your sentence on count 2 will be 5 years. Count 1 is to serve. Count 2 is consecutive probation. In 25 SC 004660, your sentence on count 1 is 4 years to serve. Same with count 2 will be 5 years to serve. That will run consecutively and will be probated. Count 3 is the misdemeanor, 12 months to serve. That'll run concurrently with count 1. Got to make sure I'm keeping track of all the numbers. That gets us to the 2 2s. So in '25 SC 006228, your sentence on count 1 is 4 years to serve. Count 2, 5 years probated, consecutive to count 1. On 229 is just 4 years to serve, only 1 burglary in the 2nd degree. And then in the case ending in 230, count 1 is 4 years to serve, count 2 is 5 years consecutive probated. Your probation is the same in all of the cases. Special condition number 1 is that you stay out of Fulton County. You can be in DeKalb County, you can be in Clayton County, you cannot be in, or any other county, but you stay out of Fulton County, Georgia. Unless he's going to need to go to the Georgia Justice Project's office. I hadn't thought about that. That will be a resource base for him. Is that correct?
That's correct.
The place you can be in Fulton County is the Georgia Justice Project. So obviously getting to and from wherever you end up living, probably initially with a family member in DeKalb, you can go to the Georgia Justice Project's nice, by then it may be a different building, but or a larger building. Additional building. But that no Sandy Springs, they're not in Sandy Springs. No Lenox Mall, they're not at Lenox Mall. Nothing like that. DeKalb County, anywhere else in Georgia, and the Georgia Justice Project's office. Another special condition of your probation is that, well, it's not going to be a condition of your probation. I am recommending to the Department of Corrections, and this will be on each of your sentences, that you participate in their RSAT program. They'll evaluate you to see if it should be what we call IRSAT, which is an integrated RSAT program that has a separate mental health component to it. But addiction is a mental health issue anyway, and RSAT is targeted at that. It is like drug court. The difference is you can't walk away from it. And I hear you on Hope House, but I worry that Hope House isn't structured enough for you. In fact, I heard both you and your lawyer say several times, I need something maybe more structured than that, and you were looking to drug court. We actually, when we are escalating from drug court, we go to Hope House because that's residential. You actually are there, you live there, but you could wake up one morning and walk away. And my concern is just looking at how long you've been at this and the addiction has been driving you the way it's been driving you, that you need treatment you cannot walk away from. And that's RSAT. And it could, residential substance abuse treatment. That could have been through probation, but if I sentence you both to time to serve on new cases as well as on a revocation, you're going to go to the Department of Corrections anyway. And so I am recommending to them that you participate in their residential substance abuse treatment program. 4 years may seem like a long time. Let me give you two little layers of silver lining. One, you get credit for all the time you've served. You've served about a year anyway, maybe more if you add up all the pieces from these different arrests. Although, as Mr. Amar pointed out, a lot of this wasn't a lot of arrests, first of all, and a lot of the behavior clustered post plea in your 24 SC case. But you'll get credit for at least 292 days. That I know. I've seen that in the system. Number two, if you successfully complete the RSAT program, Department of Corrections tend to move people to aftercare, which is treatment on the outside, halfway house, already focusing on how do I reintegrate into the community, either through their reentry program or in one of their halfway locations, because you will have been pretty focused on sobriety. And then the idea is let's keep working on that outside the environment of a Georgia Department of Corrections facility. I don't control any of that. I'm not GDC's boss, but I certainly can recommend it. Your record speaks for itself, and you'll go to the diagnostic facility and you're going to want to advocate for yourself in the way you've been doing it now, the way you've been making her job easier by saying, you know what I need drug treatment, and it needs to have an angle to it that's looking at PTSD. Good drug treatment, which you'll get in a place like RSAT, looks at the person and the root causes of the addiction. And it sounds like for you, a big piece of that is PTSD. So that will be addressed. Whether they say that's through the IRSAT or just RSAT, the experts will make that decision. I'm not comfortable coming up with a sentence that just gets you back out without having some treatment baked in first. It's not for want of trying on your part or your lawyer's part. And I want to say lawyer, the team's part. Georgia Justice Project is a team, and there have been people pushing and advocating for you. I understand why drug court didn't take you. I don't fault them. Part of it may have been it didn't go well with Veterans Court. Part of it clearly was it's just there are too many moving parts. The Alabama piece complicates it as well because you couldn't start drug court anyway. You need to resolve whatever's going on in Alabama. So I don't usually talk that much about the sentence, but you deserve an explanation because it's a little different from the effort that the Georgia Justice Project has invested in. But I think that level of structure, to me, most balances these competing interests I've got of getting you treatment, your record screams for it, and acknowledging what you've done in the community, which hasn't hurt people. No one's left bleeding. But you disrupt businesses. You take things that don't belong to you. You make people feel less comfortable in their work environment, et cetera. And you've done that so many times that there got to be consequences that flow from that. And that's where I come down on that. Ms. Davis, you had a few other conditions like anti-theft and whatnot. And I'm aware you asked for that. But given how I'm structuring it, any other conditions on probation?
No, Your Honor.
Okay. Mr. Amar, any input you want?
No, Judge, that's fine.
I want to deal with the revocations, and they were on the calendar, so I don't need to get a due process waiver. What I'm going to do in 13 SC 120968 is revoke 3 years of that probation with no credit for time served and close that one out. That's your oldest case, and there's actually more probation left on that. You don't need more probation on that case. Let's have a 13 SC case go away.
Okay.
And in your 24 SC case, the one from just last year, I will revoke 3 years and I'll suspend the balance. And again, not credit for time served because those 3 years prospective will not extend your overall sentence, given that I gave you 4 years where you have to get credit for time served on your newer cases. So that'll close out those two, one very, very old case and then your case from last year. But you heard me talk about it. You will be on probation for, I think it's at least 4, if not 5 cases. But it's 1 probation officer, it's not 5 probation fees. I will waive your probation supervision fees for the first 6 months after you get out. You're gonna be wanting to get on your feet, and the last thing you need to do is go to Sandy Springs and break into an office so you can pay your supervision fee. So 6 months to figure something else out. Family will be there, the Georgia Justice Project will be there to help you move in a more productive direction. Do you have any questions about anything I've described?
So the sentence will be straight 4 years.
Correct.
I mean, everything will be run concurrent.
Concurrent. All those sentences I mentioned are all concurrent. And so it's 4 years, but it's with credit for time served, so back out 292 days. But on some of those cases, it was followed by 5 years probation.
Okay.
And you'll be paroled at some point. This is parolable, and the state withdrew your recidivist notice. So you will likely be paroled out, and then your probation will start, and you'll be on probation for a while. If things don't go well, if RSAT doesn't stick, or for whatever reason you didn't get into RSAT, and we need to get you into the Metro Atlanta Day Reporting Center because you violated probation, we'll work through that. Mr. Amar or one of his colleagues will be here. But the structure I've described is let's get you that custodial drug treatment, and then you'll be on probation so that if there is aftercare, there's supervision during that aftercare. Any questions?
Understood.
Okay. Thank you, everyone.
Okay.
Ms. Simpson, did you need to add anything other than you'll need to report within 48 hours? Okay. All right. Thank you.
Can I get a couple?
Judge, I know you addressed Mr. Brown, but Ms. Wood also said maybe potentially a plea from Mr. Brown that was on the calendar.
Yeah, I think Mr. Brown got null prost unless it's a different Mr. Brown. Okay. All right. So let's do this sentencing situation first. Mr. Abadi, are we doing part of the sentencing today or we'll do it all tomorrow morning? Okay. Family can be here? Okay. If folks can be here at 9 o'clock, we'll get started at 9 o'clock. Is that too early? No. Okay. Can we have get Mr. Tuitt here at 9 o'clock? 9 o'clock work for you? And that relative can be here at 9?
Simultaneously.
Excellent. Thank you. Mr. Tuitt's? Yes. But that'll be tomorrow at sentencing as well. And we have another plea tomorrow morning, it looks like, so hopefully you can.
I'll be on for Ms. Fish. She informed me that could be in this.
Oh, okay. Well, if you Zoom in or whatever, just to have you plugged in would be good. All right, thank you. Yes, sir. I didn't mean to keep you guys. You could have just told Ms. Nelson 9 a.m. works, but you got a bonus 8-case plea. So did the jurors give you feedback about your need to improve your IT skills?
They knew it wasn't us.
Oh, thank goodness.
Absolutely.
Just have the pictures up. All right. Thanks, guys. Ms. Wood, you have 2 things, I think, that I need to understand what we're doing. We have Mr. Blunt, who's been here with a very quiet child, and the other Mr. Brown.
Yes, Mr. Blunt, we're gonna continue talking with Ms. Davis. That's not gonna resolve today.
Okay, so Mr. Blunt, and we don't need to get it on the record. You heard me say it. today was the day where you could withdraw your plea if you didn't like the sentence you got. Because you're not working it out today, which is fine, just know that whenever you do come back next, either for a trial or a plea, you're bound by whatever sentence you receive. Does that make sense? Okay, I appreciate your patience. And Ms. Wood will be in touch with you. Is Mr. Blunt on the October or let's look him up.
I think November.
I think most people were on the November. Was he on final plea? So much paperwork. Yes, position, yeah, the 13th. So your trial calendar is not for a month. It's on November 13th. So the latest you'd be coming in here to say we've worked it out is the 13th of November. That's a long time from now. I'm hopeful if you guys do sort something out that we see you before then. But if not, make sure you are here at 9 a.m. on the 13th. And Ms. Wood will remind you, but no, that's the latest date you'll need to be here, okay? Bye, young lady. She was so quiet.
You're good.
Some of you loud kids. So then that gets us to Mr. Whoop, hold on, let me mark this. Trial. So from this morning, we had Rodney Brown,
Yes.
and that's going to be a plea. At the other Brown, you hit a home run.
Yes.
And go, I appreciate Ms. Nix doing the right thing there. And Ms. Joyner, we did the waiver and scheduling. Okay, so Rodney Brown. We're ready for Rodney Brown. I hope he gets into arson.
So too. But yeah,
That was so many cases.
that snowballed on me so quick. I said, whoa.
Yeah. Well, I don't think you were the first to be doing, it was probably Dilligard who had it
Yeah,
first,
it
and
was
she's like, hey, ooh, hot potato. And then, whoop, another case, another case. Mr. Brown, if you come stand next to Ms. Wood, please. Are you ready?
Oh, yes, Judge.
Okay.
No doubt.
Ms. Rivers, you ready? All right, we're going to get on the record in 25 SC 005291, State versus Rodney Brown. Mr. Brown is in court with his lawyer, Ms. Wood. We have Ms. Davis for the state. And Mr. Brown, Ms. Wood tells me that you are interested in resolving your case today. Is that correct?
Yes, sir, Your Honor.
Okay. Ms. Davis is going to put you under oath, ask you a bunch of questions about your rights and this case. You'll need to answer all those truthfully. If at any time during our conversation you're confused about what we're talking about, you just got a question, will you let me know?
Yes, sir, I will.
Then let's go forward.
Please raise your right hand. Do you swear or affirm the testimony that you will give in this matter before the court shall be the whole truth and nothing but the truth?
Yes, ma'am.
Okay, you can put your hand down. Please state your true, correct, and legal name.
Rodney Brown.
How old are you and how far, are you under the influence of any alcohol, drugs, or medication at this time?
No, ma'am, I'm not.
Is there any medication that you normally take that you have not taken today?
No, ma'am, not.
How old are you and how far have you gone in school?
I graduated and I'm 44.
Graduated high school, college.
I got an associate degree in horticulture, but I graduated with a GED and then I did that.
Where did you get a horticulture degree?
The University of Cincinnati is a small little college. You know, I do like, you know, if you heard of agriculture, they deal with animals. I deal with plants, like cutting down trees and
Got it.
irrigation and flowers
Okay.
and stuff like that.
But like the University of Cincinnati, like the Bearcats or whatever they're
No,
called?
no, it was like a small college. It was a smaller college. It's called
Okay.
like, it's like more like a Voltech college.
Okay.
Yeah.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you're charged with the following offenses in indictment 25 SC 005291? Willful obstruction of a law enforcement officer and theft by shoplifting.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Attorney Wood, about all the facts and circumstances known to you regarding this indictment, including any potential defenses?
Yes, ma'am, I have.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Attorney Wood, do you waive formal reading of this indictment and any and all defects therein for the purposes of this plea?
We do.
Mr. Brown, do you remember being arrested on these charges?
Yes, ma'am.
Your Honor, the state's unaware of any outstanding warrants related to this matter. Attorney Wood, are you aware of any outstanding warrants related to this case?
I am not.
Mr. Brown, has your attorney advised you of the minimum and maximum sentence for each charge to which you are pleading to today?
Yes, ma'am.
For the willful obstruction, it's a minimum of 1 year, a max of 5. For theft by shoplifting, it is 1 year to 10 years.
Yes, ma'am.
Do you understand that today you are entering a negotiated plea of guilty, which means the state will make a recommendation to the court?
Yes, ma'am.
Do you understand the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that there are multiple charges to which you are pleading guilty today, and the court has the right to run those sentences consecutively?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of that sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess a firearm while on probation?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including federal courts?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in crime, you be guilty of a felony which can carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, use, or possess or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes, ma'am.
Do you understand by pleading guilty or giving up the following rights? I'm going to go over 9 and then ask you, do you understand? Okay. The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand?
Yes, ma'am, I do.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for the felony charges to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
How do you plead to the charges in indictment 25 SC 005291, willful obstruction of a law enforcement officer and theft by shoplifting?
Guilty, ma'am.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Your Honor, the state believes the evidence would show at trial that on August 6, 2025 at 375 18th Street Northwest in Atlanta in Fulton County, the defendant, identified as Rodney Brown, was observed selecting and concealing and passing all points of sale with several HP ink cartridges, totaling approximately a little bit over $500. This occurred in Atlantic Station's Target when officers did attempt to place him under arrest. He bit an officer. And that's the violence.
Okay.
The state is making a recommendation for Mr. Brown to do 5 years to serve 60 days, the balance on probation for him to complete an anti-theft course, stay away from Atlantic Station, and to complete 40 hours community service.
All right, let's hear please from Ms. Jackson, criminal history on Rodney Brown.
Yes, sir. There are 19 cycles. The last arrest was January the 16th, 2024 out of Florida for not complying with the register. He does appear to have an outstanding hold out of Florida for a failure to appear. The date on that warrant was February the 22nd, 2024. And he does have felony convictions. There was one in 2017 out of Florida for a failure to comply with the register. And there was one in 2005 out of Oklahoma for the actual CWAC conviction. And there is a misdemeanor conviction that was in 2018 out of Clayton County for a DUI. And he received a nolo contendere sentence in 2000 out of Oklahoma for assault and battery. Nothing in addition, Your Honor.
Thank you, ma'am. And I think we are done for the day with the criminal histories. Appreciate your help.
Thank you. Have a great one.
You too. Ms. Wood?
Thank you, Judge. Mr. Brown is 44 years old. He does have some college education. He has 3 children. He's been here in Fulton County for 65 days. He is eager to move forward and take care of his business in Florida. That hold is active from what I can tell. So we would just ask that you accept the state's recommendation in this case.
Where's home for Mr. Brown?
Well,
I have family here and I have family in Florida, you know. My brother, I work with him down there, and my uncle actually owns a tower company down this way, so I work with him sometimes. So whoever give me the best job offer, to be honest, when I get out, you know, to get my life back on track.
Got it. How old are your kids?
8, and I have a 9-year-old, 2 twins.
The twins are 8 or the twins are 9?
The twins are 9.
All right, so 1 8-year-old, 2 9-year-olds. Got it. And are they all in the same household?
Yeah, they don't. They're not with me right now. They're with their mother. You know what I mean?
Right, but one mom for all 3 kids.
Yeah.
And are they in Florida, Oklahoma, Georgia?
They're back home in Oklahoma.
Oklahoma.
Yeah.
So you've got kids in Oklahoma, family in Florida, and then one of your brothers is in Georgia? Is that
My aunties are here. My uncle's here. I have a brother here.
okay?
You know, mostly all my family is down this way and then in Florida.
Okay. Would you say more family is in Florida or is more family in Georgia?
About the same.
50-50?
Yeah.
Do you have family besides your kids in Oklahoma?
My grandma stays down there. She's like the only one. Like all her kids kind of migrated this way for like a better opportunity with their businesses and stuff like that.
Got it. Okay. So I'm asking about the locations because if you're going to be on probation in Georgia, it's hard for you to then be in Florida. If you know you're most likely going to be in Florida, then either we do probation here, you have to be here for a while and you transfer it, or I do a suspended sentence that says stay out of Georgia and you're down in Florida. But I don't know where you expect to be right off the bat.
I can be honest with you, Your Honor. I would love to have the suspended sentence and stay in Florida close to my mom, that she's getting up in age and stuff like that. You know, she's starting to forget things. But if I was to ever come back, I will let law enforcement or probation know, and I would ask to come back and not just like come back without, you know, permission. Cause I'm tired of coming in this jail. I'm tired, even though this is my first, I'm just tired of going to just do this my whole life. You know what I mean?
You're getting up there and being out of jail is probably a better situation.
It's breaking me down, to be honest with you. I can't do this no more in my life. You know, I
Okay.
have enough.
Well, you shouldn't bite the police officers then. Okay. So what I'm going to do, well, first of all, Mr. Brown, I find there's a factual basis for your plea, and that your plea is knowing and voluntary, meaning you've understood what we talked about and no one's forcing you to enter this plea.
Yes, sir.
Ms. Wood, can someone in my office sign the indictment for you?
Yes.
Ms. Davis?
Yes.
And Mr. Brown, is it okay if we electronically sign your name to the indictment indicating your guilty plea?
Yes, sir.
All right. What I'm going to do, Mr. Brown, is sentence you on the theft by shoplifting. Did you say is 1 to 10?
Yes, Judge. I think it
Okay.
has to be over.
Yeah.
I think it is because it's over 500.
Mhm.
Okay. All right. I'm going to sentence you, Mr. Brown, to 5 years to serve 6 months with the balance suspended. The special conditions of your suspended sentence are, number one, that you stay out of the state of Georgia other than, I can't actually banish you from the entire state. So I need to give you a circuit in Georgia where you can be. Should have looked this up in advance, but didn't think of it till the end. The Eastern Judicial Circuit, which is Chatham County, which is Savannah. So if you're going to be in Georgia, you can be in Chatham County. Otherwise, you'd be violating one of the conditions of your suspended sentence. So you don't have a probation officer, but if you got picked up in Macon and the prosecutor's office got word that Mr. Brown got arrested and it was in Macon, they could come before me and say, you need to revoke some of that suspended sentence because he wasn't in Chatham, he was in Macon or Atlanta, any of these places that are not Savannah and the county in which Savannah lies. The other special condition of your suspended sentence is that you obey the laws of Georgia, the other 49 states in the United States. That's a long way of saying if you get arrested in Oklahoma again, that would be a basis to revoke some of your suspended sentence here. So when you get out, there'll be this 4.5-year clock that's ticking. You're not reporting to anyone. No one's looking over your shoulder. You can be down in Florida. You just can't be in Georgia. You could be in Oklahoma. You could be in Montana. But if you get arrested, charged with something else, and that comes across the prosecutor's radar, then they could take out a warrant to get you brought back here, and we would talk about revoking some of your suspended sentence. Does that make sense?
Yes, sir.
Okay. You'll get credit for all the time you've served. You'll be in custody a little while longer, but the benefit of this sentence from the other one we've been talking about is it's followed by you being able to head on down to Florida and do your own thing. Okay?
Yes, sir. I appreciate it. Thank you for everything, Your Honor.
Well, good luck with things. I hope you are able to reconnect with their kids. I bet they would like to see you around sometime.
Yes, sir.
Ms. Wood, anything else?
No, Judge, thank you.
Ms. Davis?
No, Your Honor.
All right.
Thank you, Ms. Davis.
Did I ask him to sign? I did. Yeah, thanks. It's like, did he brush his teeth? Like, why does he need to brush his teeth?
You know, Warren don't be doing that. That's been going on.
Ms. Davis, no cross count one?
No, I sentenced him, it was both counts were, I'm sorry, I probably didn't say it, were 5 years to serve 6 months. Same sentence, both